Good morning. Good morning. Good morning. Good morning. Welcome to another session of disorder in the court. So, we are on day 5 of the James CRUMBLEY trial, and things are moving fairly briskly. So, I started things a little later than usual because we had 2 people this morning testify, and then the defense rested. And good morning, Sparkles. And then the defense rested, and then they went to lunch. And so my plan is for us to watch this testimony until they start the closing arguments after lunch. So one of the people who testified is they recalled this the state recalled this witness to the stand, and then after this witness that we're looking at right here, the state rested, and then the defense called James CRUMBLEY's sister to the stand. So, I'm super interested in what she has to say. Good morning, Solo. I'm super interested in hearing what she has to say, but I also don't want to skimp on, this other follow-up testimony from this officer. So, without further ado, I'm going to go ahead and hit start. I'm a little confused because what they did on this particular stream we're looking at is they ended it rather than continuing it until waiting for after they get back, but I'll deal with it on the back end. Yeah, no worries, Sparkles. We know you're there. We know you're there. So I'm going to go ahead and start this testimony, but it sounds to me like the jury's going to be in deliberations by something like 2:30, 3 o'clock their time. So I kind of doubt that there would be a verdict by the end of the day today, but there may be a verdict tomorrow at this pace. So we'll see. So yes, please remember to hit the thumbs up, and let's get started.
Go ahead. Thank you. Good morning, sir.
Morning.
Sir, you're one of the officers in charge of this case?
Yes,
Okay. And you were here yesterday for Lieutenant Willis's testimony, is that right?
that's correct.
Okay. And you've had the opportunity as well to review surveillance footage of different facilities?
Yes,
Okay. Does that include surveillance footage of 1111 Bellevue in Detroit?
it does.
Okay. And do you recall when Lieutenant Willis was asked if he remembered if James or Jennifer CRUMBLEY ever left the premises of 1111 Bellevue, he couldn't remember the answer?
I do recall that, yes.
Okay. Do you have a definitive answer for us?
Yes,
Tell us about that, please.
yes. So in my review of the video from 1111 Bellevue, I did not observe Mr. or Mrs. Crumbley leave the premises. They did, like we stated yesterday, go to their car several times to smoke cigarettes and come back inside, but they did not leave the premises from what I saw in the surveillance video.
Okay, so we have surveillance video admitted already about 11:30 a.m., around noon a.m. with the time difference on the surveillance camera, that James and Jennifer CRUMBLEY arrived in the parking lot. Is that right?
I believe that time is correct.
Okay, and then we saw footage of James CRUMBLEY pulling the vehicle out and back in the same parking spot?
Yes,
Okay, but they never left that location of 1111 Bellevue?
I did not observe them leave, no.
Okay. We heard testimony regarding certain foodstuffs were found in Suite 130 in that location.
That's correct.
In the review of your video, were you able to give us information regarding that?
Yes.
Tell us about that, please.
So in the afternoon, at some point, the owner of that art studio that they were staying in got into his vehicle, departed, returned a while later with white grocery bags, a bag of ice, and I think a case of waters that he made 3 trips in and out, carrying that into the apartment or into that unit. And then that was the person that dropped off those groceries.
Okay, thank you. I have nothing further.
Very briefly, Your Honor. Good morning, Agent Brandon.
Morning.
You testified that James and Jennifer left the building, but remained on the premises.
That's correct. Yeah, they were a little out of view of the camera by the front of the vehicle, but from my observations, they would go out there for a few minutes and then walk back in.
From what you recall from your review of the information that you received during your investigation, it wasn't just once or twice, but they actually went in and out of the building multiple times that day, correct?
Yes, I don't recall the number, but it was probably north of 6. And sometimes it would be both of them. Sometimes it would just be Mr. Crumbly. You know, occasionally it would be Mr. Crumbly's particular would come out with his hood up or ball cap on and then walk back in.
And we saw it was snowing that day.
I believe it snowed in the morning, and then as the day went on, it let up. But yeah, it was approaching winter.
It was December in Michigan, so cold.
I don't recall the temperature, but yeah, it was December in Michigan.
You also, if you recall, there were times when Mr. Crumbly or his wife left the building and went back in during the day, but also at night.
Yes, it started when they arrived and then continued through the evening. Yes.
As for the owner of the art studio going to get foodstuffs, I think is what the prosecution referred to it as. You don't know why he went and got it. You just know that he went and got it. Is that fair?
Correct.
No further questions, John.
No redirect, thank you.
All right, you may step down.
Thank you, Ron.
And who's the next witness?
That was a very, very quick recall. So what happens now is the state goes through, some exhibits with the judge that it's a technical and boring conversation, and then they say the state rests. And the defense doesn't seem totally prepared for that, but you see right there that the defense passes a note. You'll see right here. I'm going to show you. She passes a note back to, I think, one of her colleagues, and I think that means I think that
Judge.
note
I did speak with counsel last night as well as this morning.
Let Jennifer know she's up. Or
Not
not
I will
Jennifer.
provide the court as well as counsel.
Let the
with,
sister know she's up.
updated version. I have made a record before we started with testimony regarding exhibits that were admitted. I'm not going to go through all of them, but I will rely upon the document that I provided counsel as well as the court.
Go get
These
the
exhibits
sister.
are admitted.
Yeah, we made an extensive record of which exhibits would be admitted last week.
So they talk about exhibit.
It's accurate.
I do believe it's accurate, Your Honor. Yeah.
They're currently not.
370.
And I believe Mr. Keith will do that to give me a copy of that list to.
I want to hear her say, I call this witness.
Crumbly?
Ms. Lehman.
Yes, Your Honor. At this time, the defense would call Karen Crumbly.
Karen Crumbly. It must be hard being his sister right now.
Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, self to God? Okay, and could you hold this sword toward you?
I got it.
And have a step up. And have a seat. And then would you state your name for the record and spell your first and last name?
Karen Crumbley, KAREN CRUMBLEY.
All right, I'm gonna ask you to keep your voice up.
Okay,
All right, take a deep breath.
okay.
Go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, Ms. Crumbly. Can I call you Karen?
Yes, ma'am.
Thank you. Karen, I am gonna again ask that you keep your voice up. You are a little soft spoken, so I want to make sure that the jury and the courtroom can hear you, okay?
Okay.
I just have a few questions. How are you feeling today?
Good.
Are you nervous?
Hey, Tiggy girl.
Well, I mean, yes, a little. I mean, I'm all right.
I'm gonna take you back. Well, let me start with this. Do you know James Crumbly?
Of course, yes.
How do you know him?
He is my brother.
Do you know his son?
Yes, I do.
I am going to ask that you not say his son's name. We do have some direction from the court not to use his son's name in court.
Okay.
And what is his son's relationship to you?
He is my nephew.
We're going to be fairly specific. Where do you live?
I live in Welaka, Florida.
Tell the court a little bit about yourself.
I was raised in Jacksonville, Florida.
All the way.
I went and graduated high school, and then I got my medical assistant degree and did a few times in New Hampshire at Dartmouth-Hitchcock Hospital, and then came back to Florida. And I was in a car accident where I lost my right leg, and now I stay in a town that is peaceful, and I have 4 children and 2 grandchildren.
How old are your kids?
17, 18, 23, and 25.
I'm going to take you back to 2021. Where are you living in 2021?
In Welaka, Florida.
Specifically, I'm going to ask you about April of 2021. Do you recall what was going on in April of 2021?
My mom was in the hospital. My mom passed away April 6th of 2021.
Do you recall if you saw James or his son in April of 2021?
Yes, I did. My brother James was there in the hospital with us when my mom passed. And then my nephew came down, I believe, the day after and stayed for the while we had the services. And then we had like a memorial thing, like get together with everybody, cookout and stuff. And then we had the services, the funeral services and things like that.
You said your mom passed away on April 6th of 2021?
Yes, ma'am.
Do you remember exactly that your nephew came down on the 7th, or are you not sure of the date? And if you don't know, it's okay.
I know that they left when they found out that my mom had passed. I believe my nephew
Let
and
me
his
stop you for
mother.
a second. Who's they?
My nephew and his mother
Okay.
drove down to Florida from Michigan when they find out, and believe they got there maybe around on the 7th that they arrived.
Okay.
Long drive.
So you remember that you saw your nephew maybe the 7th. It might have been the next day, or maybe you're not sure.
Right. Yes.
But it was shortly after the 6th.
yes. It was very shortly.
While your brother and his son were in Florida, did you spend time with them?
Yes, I did.
Obviously, it was a difficult time with your mom passing away. Do you recall seeing anything concerning about your nephew?
No.
Do you recall him saying anything concerning to you? And if I ask you about if you recall if anyone,
Will you keep your voice up? Just
Yes.
I want the jury to be able to hear.
Okay, I'm sorry.
thank you, Judge. When I ask you if you recall hearing anything or anyone saying anything, I don't necessarily want to say what they said.
Okay.
That's not allowed. But just if you recall hearing anything.
No.
Do you recall having conversations with your brother where he expressed anything concerning to you about his son?
No.
Do you recall your brother expressing any conversations he'd had with his son that were concerning to you?
No.
Good morning, Higbee Chick.
Do you recall how long they were there?
I think I'm not honestly too sure. 1.5 weeks, maybe a week.
Okay.
For sure, for a week.
So it was more than a couple of days.
Of course, yes.
And you saw them more than one time.
Yes.
And when I say them, I mean both your brother James and his son.
Yes, ma'am.
Do you recall seeing James and or your nephew any other time in 2021?
Hi, Marie.
Yes, I went to Michigan with my father and my stepmother to visit. It was actually he knew my father was going, but I was a surprise to my brother. And we went to Michigan. We stayed at their house for about a week.
When you
About
say
3 or 4 days, maybe.
when you say you stayed at their house, whose house did you stay at?
My brother James's house.
And was his son there?
Yes.
And you stayed there for a few days.
Yes, ma'am.
Did you spend time with James and your nephew in those few days?
Yes, ma'am.
And I'm going to ask you the same thing. Do you recall seeing anything concerning?
No.
Do you recall your nephew saying anything concerning to you?
No.
Do you recall your brother talking to you about concerning conversations he had with his son?
So I just have to object to that question. Honestly, I should object to the last question regarding April as well. She can testify as to what she observed and what, but not what James said or not said.
Yeah, correct, yes.
From your observations, did you see anything concerning in June of 2021?
Absolutely not.
And did you speak with your brother after June of 2021?
Yes.
Did you speak with your nephew after June of 2021?
Not directly, no. Heard him in the background, tell him I said hi, he said hi, things like that, but not directly, no.
So based on those interactions, although they weren't direct, they were kind of in the background,
Yes.
did you observe anything concerning with your nephew between June of 21 and we'll say November 30th of 2021?
No.
If there had been anything concerning that you had observed, what would you have done?
I would have addressed it, and if I would have known anything, I would have talked to him, I would have took him home with me if there was any kind of inclination that anything was wrong.
Would you have made your brother aware of it?
Of course.
Did you ever make your brother aware of anything you were concerned about?
No, because there was nothing I was concerned about.
I have no further questions, Your Honor.
Ross?
Good morning.
Good morning.
My name's Mark. I'm going to ask you some questions. If anything I ask is confusing or
Knowing what I know now, and that is the defense's only witness, that didn't speak very much to. I don't think I don't think that was super convincing for the jury. They don't. Yeah, that's what I was about to touch on, Johnny. It doesn't sound like they were really involved in each other's lives. I mean, she lived in Florida that entire time. They lived in Michigan. It doesn't sound like they were super close. Would she know if anything was wrong? If the parents didn't know who lived with him, and are they the type of family that would have been aware? Anyway, it's just is that all you got, defense?
sometimes I kind of go on a little bit. Just let me know when I can rephrase the question.
Okay.
Now, James Crumbleigh is your brother, obviously,
Correct.
and we refer to him as the shooter. He's your nephew.
Yes.
Okay. The last time you actually saw the shooter was June of 2021. Your nephew?
Do you mean in person?
In person, yeah. The last time you saw him?
I think, Your Honor,
Oh,
she's hesitating. I think I know what she's hesitating about. Do you want to discuss it at the bench?
can we approach? Yes. I think I know what it is.
It's interesting. So the question he asked was, so the last time you saw him was June of 2021, and she hesitated, and I guess there's some sort of order related or some sort of sensitivity related to the last time she saw him. The grandmother died in April, and that's when the family went to Florida.
Thank you. Before the shooting on November the 30th, the last time you saw your nephew was in June of 2021.
Correct.
Okay, and the last time you saw him before that was in April of 2021.
Correct.
Okay. And you, from the time of actually, you may not know this, but everybody's phones in this case were seized and analyzed. Did you know that?
Yes, sir.
Okay, including your brothers as well as your nephews?
Yes, sir.
So you're not here to tell us that you had a particularly close relationship with your brother, is that right?
We had a close relationship, but we lived in two different states, so it was mainly, it wasn't like close.
You wouldn't talk very often.
At least maybe once a month.
Well, according to the phone records on your brother's phone, it was far less frequent with that. Does that sound right to you? And I'm not trying to trip you up.
No. We talked on social media as well.
Right. So there's call logs, actual device to device.
Right.
Then there's Facebook calls as well.
Correct.
And I show 2 Facebook calls.
Okay.
And then there's instant messaging, and there's 22 instant messages between you and your brother.
Okay.
And that's the entire year of 2021.
Okay.
And then there's some group Facebook messages
Right.
with other members of the family.
Okay.
Now, your nephew never wrote you a note that said, "Help me,"
No,
Did he?
sir.
and he never drew a picture next to that note with a gun, did he?
No.
Okay. And that would be concerning to you.
Yes.
Okay.
It would
And is
cause-
that what you meant to say, or is that what you meant when you said, what would you have done if you saw something of concerning nature?
I would have brought it up, yes.
Yes, that would be something significant to you as a mother.
To address, yes, of course.
I just want to, I think it may have glossed over, I want to clarify. On the phone log, there's only 3 actual phone calls between you and your brother in 2021.
Okay.
Does that sound right to you?
Yeah, I
Okay.
guess.
Ouch. On the phone logs, there are 3 phone calls between this woman and her brother in 2021. So Marie, you say that she visits the shooter in jail all the time. Do you have that from the records or something? Is that something you heard about? I'm just wondering where you got that information. I'm not doubting you at all. Just don't know that information. And, you know, it doesn't surprise me a lot that she would visit him in jail. Because, well, maybe some of it surprises me, but anyway, a lot of times people do get closer after tragedy happens. Yeah, well, I maybe he'll follow up with a question about messenger and texts and calls, you know, and the frequency of their communication. But, you know, it does go to show that, you know, when you have a closer. Oh, really? That's interesting, Marie. So she went into Jay's chat? Very interesting.
Now, you were interviewed in November of 2023 by an investigator when your name was put on the defense witness list. Do you remember that interview?
Yes, sir.
And you were asked if you knew you were on the witness list, and you said that you didn't know at that point.
Right.
Okay. And then you said you would have nothing to testify on their behalf because you had no knowledge of the incident until after it happened.
Correct. I had no knowledge of the incident.
Okay. So then you said you didn't know that a gun was bought for your nephew prior to the incident.
I did not know about that weapon, no.
And during that interview, you were asked about guns in the family home back when everybody lived in Florida. And you said, well, you know, some firearms is something that wouldn't be out of the ordinary for someone to own back in Florida when you grew up.
Right,
Do
no.
you recall that?
Yes, I do
Okay.
recall that.
But then you said, having guns in the house wouldn't be out of the ordinary, but getting one for your kid would be. At 21 minutes into the interview,
Out.
Getting one as in,
giving a gun is a,
no,
gift for
not
your
giving, but to use at a shooting range or whatnot.
well, I'm just
I'm
reading
not saying normal.
your words. And again, I'm not
Okay.
trying to trip you up.
Yeah, no.
You
Okay.
said getting a gun for your kid, that would be out of the ordinary.
Yes.
Hello, Lucia.
Thank you.
Yes, Your Honor, thank you. The prosecutor asked you about guns in the family home. And you were aware, or let me ask you, were you aware in April or June of 2021 if there were firearms in James Crumbley's family home?
Yes.
And what do you know about those firearms, if anything?
I know that there was a Derringer because I saw and held it myself when I was there in June.
And how did you go about seeing and holding it?
He took it out of his room. I had brought it
Let me
up.
stop you. Who's
Okay,
he?
sorry.
Took it out of
My
his
brother,
room.
James, took it out of his room to show, because it was, I guess it's maybe like an antique kind of ish gun. I'm not sure. I don't know really too much about them, but and I wanted to see it and I hold it, and it was very heavy. And then afterwards, he put it back in its case and brought it back into his bedroom.
You said you're not very familiar with guns, right?
Correct.
The prosecutor asked you about a statement that you made about getting a gun for your kid would be, I don't remember the word used, odd or something along those lines. Is that right?
Yes, ma'am.
What did you mean by that? It sounded like you were trying to explain that to the prosecutor, and I don't know if we heard it.
I mean, if you're getting a gun specifically for your child to use at his leisure, that would be wrong. But with adult supervision, and I don't see any problem with it.
I have no further questions. Ian.
Just real quick, when you were there in June, here in Michigan in June, I think, right?
Yes.
Okay. And James went and showed you the 22 caliber Derringer, the small gun.
Yes.
Okay. You said he went and where he kept it in his room.
Yes, sir.
And the whole family was there.
Yes, sir.
I have nothing else. Thank you, Judge.
Well, you can step down in your excuse. I'll watch the step right there.
Yes.
All right, who's next? Witness?
No further witness time.
You know? You know?
Watch this again. Watch what the look on his face when she says no further witnesses, Your Honor. Look at the look on his face.
Who's next? Witness?
No further witness time.
You know?
He looks like he's surprised or something, like he's expecting more witnesses, right? Like,
Just to confirm, Judge.
it's kind of like he's not with the program. He's not quite knowing what's going on. I think she might have just written him a note that he's reading.
Yes. Yes. Yes.
I know you did.
Yes.
No more about it.
No rebuttal. Thank you.
Just for the record, Ms. Crumbly, who just testified, is in the courtroom. I believe that. Is there any objection?
No, she can say she's excused.
Are there any additional witnesses?
Not for the people.
Not for the defense.
All right.
He may wonder, but he's not, because they both rest. They end up both resting, and then the judge sends the jury out early for lunch. You see here, I'm skipping through this rather lengthy sidebar that they have, and then they come back, and they're off the record for a bit more time.
All right, I apologize. I was trying to see if your lunches could be here earlier. So your lunch will arrive at 11:30. Your lunch will arrive at 11:30, and we'll be hearing closings at 12:30. All right? So I need to tell you that during the trial and between now and the time that you hear closing arguments, you must not read, listen to, or watch any news reports about this case. Under the law, the evidence you consider to decide the case must meet certain standards. For
So that's what happens there.
witnesses who swear to tell the truth.
So that was a really brief, I find myself wondering, how did his sister traveling all the way from Florida to Michigan to testify for, what was that, 10 minutes? When you really think about it, all of the things that they possibly could have done for his defense, they really must not have much, right? They don't. Well, obviously they don't, because that was it. The defense rested, and now in a half hour they're going to be doing closing arguments. So That was the defense case right there, was that testimony from from Karen Crumbleigh, the defendant's sister. That was it. That was it right there. You know, leaving me to believe that the jury doesn't have much to work with. Really? Yeah, that was a short, incredibly anticlimactic defense. Yeah, this morning the only thing that happened was they recalled a a detective onto the stand, and that was a very brief recall because he had already testified, and then the state rested, and then they went through some technical legal discussion about exhibits. She is very loud, Lucia. They went through some technical exhibit legalese conversation with each other, and then the defense brought on that witness, Karen Crumbleigh, and then they rested. And I think it even caught the judge off guard. She was trying to figure out if she could get the jury their lunch early. She could only get it as early as 11:30. So then they set the closing arguments for 12:30. So in about a half an hour. So interestingly, I want to tell you. So I've been sitting here watching the other live feeds, trying to make sure I'm not missing anything as they come up, and and there was a hot mic moment. There was a hot mic moment on the Law and Crime Network channel, as I was sitting here muted. As I was sitting here muted, you guys couldn't hear it, but there was this. It wasn't nothing super interesting was said, but the producers on the Law and Crime side were having a conversation, not knowing that they were live. So I'm going to show that to you in a second. But Johnny asked, can you give us a recap of how the sister contributed to the defense? Since I'm not a lawyer, and I always have to give that caveat, I'm not a lawyer. Opinion as a layperson who watches trials all the time, has been involved in covering true crime for quite some time, but also, I was married. The most I can say is that I was married to a lawyer and worked with a lot of lawyers. Okay. How did the sister contribute to the defense? All she did was basically say, I never saw anything. I'm smart good enough. Basically, the line of questioning went like this. You saw the shooter and his parents in April of 2021, right after your mother died, and we're all getting together in grief. Did you see anything concerning? No, I didn't see anything concerning. If you would have seen something concerning, would you have said something? I certainly would have said something. And then there was a little bit of testimony about how she visited them from in June, and how James brought out the Derringer, because it's an antique, a collectible or something like that. He brought it out from his room. He showed it to everybody, and then he brought it back out of his room. Was there anything concerning that time? No, there was nothing concerning. When the state was questioning the witness, the state asked, do you realize that there are something like 3 total phone calls between you and James in the year of 2021? And she says, I guess so, basically. So, Yeah, and Lucia, another person in chat here, is saying that the aunt, the sister of James, visits the shooter in jail quite often. You know, it's not unusual for family members to get closer after tragedies like this, for a family member to kind of swoop in and be be there for the underdog, or the person who's been alienated and has nobody. And obviously the shooter has hardly anybody. He has probably nobody at this point. Even not even his parents. Jennifer Crumbley said that she hasn't talked to her son since the day of the shooting. So basically, and they were all kind of witnesses to the whole thing, so they probably couldn't talk to each other. But I'm not even sure she would have talked to him after that, because it was pretty much all man for themselves, to each his own. We're all for ourselves now. She made sure that her and her husband were able to get retained attorneys that are now continuing to represent them, but the shooter had an appointed attorney. So very, very, very interesting. Okay, so I'm going to show you this hot mic moment that happened. It's just kind of funny. It's just one of those kind of court moments that happens in the world. Let's see if I can find it. It just happened a few minutes ago. Is it here? I don't know if they can erase it. No, let's see. I guess I have to go back a little further. Yep, I agree, Johnny. I think she was more ashamed than concerned as well. And I'm just trying to find this hot mic moment on Law and Crime. And the chat was like, hello, do you guys know that you guys are hot mic in here?
So live right now.
Here's the hot mic
I'm trying to pull you live right now. You guys are going to be dead at 22.
Yeah. So we may do we transfer for noon or for 5 or we're in 6. I guess he's at 5. Yeah. And I want to report to you that Mike Glover did not take me to lunch. They went out and got their own lunch. Did not come take me. So I tried to take him out for a beer for his birthday. He says, I'm not 21. We can go out some other time.
I have you.
Okay, let me get you a mic check here, okay? Okay, hold on. I'm gonna give you a mic check because that's important.
Mike.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We're live.
That was it. It wasn't super. It wasn't super scandalous or anything. It's just kind of funny. He's like, Mike Glover didn't take me out to lunch.
He's at 5.
And I'm trying to pull you live right now. You guys are going to be dead at 22.
Yeah. So we may do we transfer for noon or for 5 or we're in 6. I guess he's at 5. Yeah. And I want to report to you that Mike Glover did not take me to lunch. They went out and got their own lunch. Did not come take me. So I tried to take him out for a beer for his birthday. He says, I'm not 21. We can go out some other time.
I have you.
Okay, let me get you a mic check here, okay? Okay, hold on. I'm gonna give you a mic check because that's important. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We're live.
So he just admitted to trying to take a minor out for a beer for his birthday. I'm just kidding. It's just silliness. So yes, I did see that. I did, and I'm going to pull it up in one moment here. So for those of you who are not aware, Scott Peterson was in court yesterday. The Scott Peterson. And as I pull that up, yes, opinionated. I completely agree. That is actually exactly what Jennifer Crumbley said, that they chose to pay for a lawyer because their son's life was basically fucked. That's what they said. And it's a choice. It's a choice to make. It seems very in line with their choices that they made up to that time. In all honesty, it's consistent, right? So anyway, I'm going to show you that Scott Peterson was in a hearing yesterday. Now, this hearing was incredibly boring, very boring, very technical, extremely, you don't get a lot out of this. They aren't really talking about the case itself. So you don't really learn. Yeah, I understand your opinion on that. Opinionated. Solo sock man, I needed to call my brothers more often. I hate how actual distance created true distance. Yeah. So you don't really learn anything from this appearance from Scott Peterson. It's just very interesting to see Scott Peterson. It's very interesting that this case is being taken up again. I'm open. I'm personally one of those people who have felt that Scott Peterson is guilty, but I'm also open to new evidence being revealed. I'm open to, my mind being changed. And I also openly admit that I don't have all the information on this case. So, but I think it's just interesting to see him in court here, see his mannerisms, see the way he looks and acts. You don't get to see him very much, but let's show it here real quick.
Do we have your consent to proceed via Zoom this morning?
Absolutely. Thank you.
All right. Thank you. So the record should reflect Mr. Peterson has consented to.
Look at that. He has a ponytail, you guys. Scott Peterson has gone through a lot of different looks since we've known him, right? When we first encountered Scott Peterson, he had damn, he's old. Honestly, I don't think he looks pretty good. I don't think he looks bad. He definitely looks older. He looks thinner. But what I was just starting to talk about is that he's gone through a lot of, reinventions in terms of his look, right? So when we first met him, he was, young and, dark hair. He looked like just kind of your average, everyday, clean cut, kind of married, about to have a kid kind of guy. That's what he looked like. Then when he was captured, yeah, he definitely doesn't look as young as he used to be, but he looks good. Then when he was captured, he had dyed his hair blonde. He had bleached his hair blonde, and he had if I recall correctly, he had a goatee. I recall facial hair. And yeah, that's when they captured him, and I'm pretty sure that's what the mugshot has. And then, you know, as he has been in prison for the last several years, in prison for the last several years, his changes his look has even changed in prison, and he's, you know, he's been thin, he's been heavier, he's been, you know, his hair has been in different iterations. But in this iteration, he actually has a ponytail. I guess so. I guess they let them experiment in prison with their hair. I guess. I just didn't expect and I find myself imagining what it looks like down. I bet it doesn't look very good down. You know, when men get older, the older men get, in my opinion, and the older men get, in my opinion, the harder it is to pull off long hair. The harder it is to pull off long hair, you know, because they start losing their hair and it starts getting scraggly and gray, and, you know, it just looks better. Oh, I'm hearing, there's noise in the courtroom. Hold on a moment. Is this another hot mic moment? No, I think they're just, no, okay. They've opened up the courtroom. You can start seeing people going into the courtroom, but the jury isn't there. So we're going to keep watching a little bit of this. Oh no, they're pointing at the logo now again. So we're going to keep watching this.
Appearing via Zoom. He is appearing electronically from Mule Creek State Prison.
There's a closer up picture for you there, Johnny. I love men with long hair too, actually. I actually really love men with long hair. I'm just talking generally about whether they can pull it off as they get older and start losing it. Yep, he was on Zoom. Yep. So,
Okay, the court had requested counsel.
he, you know, I also want to just kind of comment on his general vibe. He looks.
Thank you. So
he looks open. He looks cooperative, right? Open and cooperative. He's always kind of appeared that way, but in the past, I feel like he's come across a little bit more punkish, you know, more a little bit more like a cocky asshole. And I'm not seeing as much of that, at least yet.
the record should reflect Mr. Peterson has consented to appearing via Zoom. He is appearing electronically from Mule Creek State Prison. Okay, the court had requested counsel to be present this morning for a status conference. There are 3 motions pending before the court. Motion for post-conviction discovery under Penal Code Section 1054.9, a motion for post-conviction DNA testing, and a motion to seal court pleadings that have been filed in relation to those 2 motions. Because we had not yet had a hearing date set, the people's response had not yet been due, so I wanted to discuss with counsel a briefing schedule and scheduling a substantive hearing on those 3 motions. I also wanted there were references in the pleadings to potential meet and confer process between the parties to see if they had any luck in narrowing the issues that the court may have to decide in terms of discovery and testing. So I wanted to check in with counsel, see where we are with that process, and then.
Oh, he's muted. He's muted.
Still muted.
Look at him. Scott Peterson dealing with the Zoom issues.
All right, Mr. Peterson, we're contemplating an April 16th hearing on the motion to seal the pleadings or parts of the pleadings in this matter. Are you going to want to appear via Zoom or in person for that?
2 is fine, thank you, Your Honor.
Okay, thank you. Then for hearing dates on the DNA motion and the 1054.9, what's the party's preference in terms of hearing those together or separately?
Your Honor, we would prefer to have the DNA issue resolved as soon as possible so that if there is going to be testing ordered, we can get that started.
Okay, people. Okay, that's fine. So if the briefing on the DNA.
This is when you watch somebody when they think they're not being watched, and you see how they continue to carry themselves. Does the mask slip? He seems more confused than anything. So it sounds like what was going on was, because we skipped right through, was the hearing was over and now they're waiting. Oh no, maybe not. No, they're waiting for the judge to come back from.
Still muted.
Always with the technical issues.
Okay, thank you. Then last housekeeping matter, the court did, okay, thank you. Last, receive an ex parte communication from apparently some kind of a spectator. I read about one sentence of it, enough to realize it was an ex parte communication. Did not read any further, and counsel have been provided, as I understand from the clerk, copies of that email. Did both counsel receive it? Okay, thank you. And the court is not going to be reviewing any incoming email to that inbox in the future to avoid that issue recurring in the future.
That's
So,
funny, Tiggy girl, instant
to
face.
Okay, is there anything else either council needs to take up for today's date before we recess?
I have one question, Your Honor.
Yes,
We have received a number of inquiries from members of the press and the media asking for copies of the motions we filed. We have not provided anything to anyone in the media or the press. Apparently, they are not on the court's website, and so I'm just asking for guidance. Is there any issue with us providing the motions, or is the court planning to put them on the website so they are available?
I don't have any plans in that regard while the motion to seal is pending, at least. And I have not made any orders about what counsel may or may not do in terms of their communication with the media. So, okay. Yes.
If people can make a suggestion. One of the things that Judge DeLuca did during the trial, because of the media attention and not wanting to be distracted by additional requests that would come in from the media once a motion was filed, his position was that he would take the motions filed by either side and he would hold them from being put on the website or from public filing until the other side responded, because a lot of times that resolves some of the issues or questions that may have arisen. So we would suggest that might be a possibility here as well.
The difficulty, and I think part of this, Mr. Harris, is that the court's filing procedures have changed since Judge DeLuca was the file. We don't have a lot of control over when things come in now because it's all electronic filing. So I don't actually see it until the clerk's office processes it. So while I appreciate the suggestion, it's not consistent with our mandatory filing procedure. Thank you all. Okay.
February 25th.
All right. So let's bounce back over to the court stream because they're going to be starting soon. Yup. They got guards at the door. They got cameras ready. Yeah, there are a lot of innocence projects. They're not all the same. There's not one innocence project.
What do you mean silence?
Yeah, I agree, Tiggy girl.
Yeah. So she wants it on an angle like this, you mean? I think straight sideways, like that. And then she's gonna be like sideways. Yeah, it's gotta come this way too.
We're hearing people's conversations.
It's hidden some. Good or more?
We are backboxing.
Probably more. A little more. Oh.
So, you know, sometimes smaller innocence projects, they will take on cases, or at least they will announce that they're reviewing a case in order to get publicity. And I know that sounds very cynical. I'm not saying that's exactly why the LA Innocence Project has announced that they're reviewing this case. And also, I haven't followed it so closely to see whether they have done more than just saying they're reviewing it. I mean, they're obviously in court, but it sounds like they're very much in the discovery phase. They could, you know, get the discovery that they're looking for and decide not to continue to follow through. But what the motion we were just hearing them talk about was a motion for post-conviction discovery. Yeah, he's been in prison since 2000, almost 20 years, Johnny. It's been almost 20 years. And it sounds like he's in a different prison right now than he was in. He used to be in San Quentin, which was is up near San Francisco, where I used to live. But it sounds like he's in a different prison now, and that might be because there's this court activity going on. I'm not sure. Yeah, he's been in prison for a long time. And like I said, my personal opinion is that he's guilty. But I'm always willing for my mind to be changed with evidence, right? With actual evidence. You know, not conjecture, not circumstantials. We already had our chances for all the circumstantials. And also witness testimony. Even if it's witness testimony, that witness better be solid and you know, witness testimony isn't even good enough these days because witness testimony is so flawed. Memories, we know now, our memories are so flawed. That is where a family friend of ours is. He killed 2 men in Orange County. We were all shocked when it happened. Still don't understand it. And it happened in 1992. Oh my gosh. That must have been shocking for you all. Are you saying that your family friend is in San Quentin? Yeah, and do you know why he did it? So I'd like to thank you all in advance for hitting the thumbs up. Also, I know that many of you watching this channel also follow my other channel, Checkmate Humanity. And oh yeah, he's in San Quentin. He was there to steal stuff, and the guy and his friend walked in on it. Wow. It was his boss's house. Wow. So a robbery gone wrong, a burglary gone bad. So, so I'm pretty sure most of you follow my other channel, Checkmate Humanity. I'm planning to go live there soon, maybe tonight, or it really kind of depends on how I feel. But I'm going to start a new show there, on a new live show on my other channel called Reality Check. Get it? Checkmate Humanity Reality Check. And it's really basically I get so frustrated and feel so incredulous when I see the way some YouTubers analyze and describe true crime cases. The absolute ignorance that they use sometimes. And my first topic is going to be, there's this one creator or true crime streamer called Bullhorn Betty. And there's a child who's missing right now. He's on the spectrum. And she started to just, talk about this particular child who's missing. He's 15. He's on the spectrum. And it absolutely astounds me how some people will start to talk about things that they have absolutely no idea what they're talking about, but they talk about it as if they know everything about it. And she started to talk about, oh, really, Music City Mom? Yeah, it's that kid, Sebastian. So she starts talking about this kid and just putting characteristics on him that she couldn't possibly know he has. She starts making all kinds of assumptions based on really ridiculous and ugly and ignorant stereotypes about people on the spectrum. She's not a mother, and she makes all kinds of assumptions about kids who are 15. It's a huge problem, Lollipop. So that's why I'm going to start doing this reality check show. And most of my content on that channel has been pre-recorded, but I have found that most of the people who do that really frustrating, ignorant content are streamers. And the best way to critique a streamer is to kind of stream, basically restream parts of their content and commentate over it. And also that's how, most of the time streamers, true crime streamers, their content about them is also watched by people who watch streamers. So you don't get a lot of crossover. There aren't a lot of people who watch most people who watch live streams would prefer to watch live streams about live streamers. You see what I'm saying? So anyway, be on the lookout if you are on my subscriber of my other channel for that live that's going to be coming up, the reality check, and this one's going to be about Bullhorn Betty's ignorant plans recently, just for general ignorance about kids and autism. It's not. I'm not saying that I know a lot about autism. I know what I don't know, and that's the issue. Is that so many strangers don't know what they don't know, but they just blah 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 like they know what they don't know. Another thing I'm going to talk about when I go live on that channel is I have an idea for offering, there's so much drama in the true crime community. We call it CRUMBLEY. And a lot of the drama goes on and on and on, and it goes round and round and round and round. And a lot of that is because YouTube incentivizes that drama. YouTube, it pays, drama sells, right? But I do hear a lot of drama going on where sometimes they really do want to resolve it. They do want a conclusion, but there's really no way of coming to any closure or conclusion. There's no forum in which to do that. And I want to offer that forum. I want to offer kind of like an informal forum, almost like a trauma court, where people would volunteer to come onto my channel and argue their disputes, and then have the chat vote for who they think should, it would be a very informal kind of forum, but they would be expected to behave like they're in court and be respectful to each other. But essentially, we would be deciding which one of them is being the asshole. I would love your guys' opinion on that, on whether you think that would be I don't know, something you would watch.
All rise.
All right, now court is back in session, and they are going to we are going to hear closing arguments.
Your Honor, calling People v. James Crumbleigh, case number 222799989 FE.
Thank you, Mark Keese, on behalf of the people.
Karen McDonald on behalf of the people.
Good afternoon, Your Honor. Marielle Lehman on behalf of James Crumbleigh, who is standing to my left.
Good afternoon, Mr. Crumbleigh, can you hear us?
Yes, I can. Thank you, Your Honor.
All right. Are you ready for the jury?
Yes.
We are, Your Honor.
All right, I will go on.
Okay, Sparkles would watch. Woo! Thank you, Sparkles. I like it too. And really it comes out of that whole discussion I was having about as I was covering Lana, and I was describing how things would, oh good lollipop. I was describing how things go down, and I was just thinking, I can't believe that we're actually in the real world here. Like, snap out of it. Let's get back to reality. This is reality, you guys.
All rise for the jury.
There's much bigger things to talk about than this bullshit drama on YouTube.
Good afternoon, you may be seated.
But I also get so sick of talking about that one woman, and there's so many other people
Ladies and
deserving of
gentlemen,
reality
the
checks.
witness, testimony and the evidence portion of this trial have been completed. We will now hear the closing arguments. Much like the opening statements, these are not evidence. They're only how each side sees the case. Because the prosecutor has the burden of proof, they also have a right to rebuttal. You also will have a copy of the jury instructions at the end of the trial and when you're deliberating, right? Prosecutor?
Good afternoon. On November 30th of 2021, around 1 o'clock in the afternoon, Lieutenant Tim Willis doesn't remember exactly what happened immediately upon being informed that there's a possible shooter at the Oxford High School. Doesn't really remember who he called or how he got down in the elevator, but he remembers one thing. Whoever he called, the first thing the caller said was, "It's real." Doesn't really remember the details on how he got there that day. But he did tell you that of all the first responder scenes he's ever experienced in his 20 plus years of being in law enforcement, this was the largest and most serious by far. And the second, what didn't even come close. Ed Wagrowski, who is now works for the Secret Service, but was worked for the Sheriff's Office in the Computer Crimes Department, told you that he went so fast that he could barely keep his tires on the road. He told you that he will never forget the look on those kids' faces because they looked like zombies. He also told you that in that moment of crisis, he will never forget the looks on the parents' faces who were waiting desperately for their kid to get off those buses. Molly Darnell, a seasoned teacher who had years and years of training on what to do in an active shooter situation, she told you that even though she locked eyes with James Crumbley's son when he fired his SIG 9mm at her and hit her, she still couldn't believe she was shot. She told you that she didn't even put it together when she felt the warmth and burning on her arm. She didn't even trust herself to recognize a voice she'd known for over 20 years outside the door. And you heard from Chrissy Gibson Marshall, an assistant principal who had hours and hours of training on what to do in an active shooting situation. And what did she do? She ran towards the shooter. She ran towards the shooter. All the training, all the preparation, and she did the opposite of what she was trained to do and what she tells everybody else to do. Because she couldn't believe it. And even when she saw James Crumbley's son with that gun, she still couldn't believe it. But she wasn't going to leave because Tate needed her help. All four of these individuals trained for years and years and years. Law enforcement, what to do in an active shooting situation. Yet, all four of them, as experienced and trained as they were, had no idea how to accept the reality that this was happening. Which is why Lieutenant Willis remembers it's real. Ladies and gentlemen, those four people, they were adults. Those four trained, experienced people were adults. These four were children. And so were the hundreds of kids in that school. What happened that day? is about the deaths of these 4 children and what James Crumbley did and what he didn't do. The shooter has been sentenced and prosecuted and convicted. He pulled the trigger. James Crumbley is not on trial for what his son did. James Crumbley is on trial for what he did and what he didn't do. James Crumbley had a willful disregard of a known danger it caused the death of 4 students in Oxford High School on November 30th, 2021. Hannah, Madison, Tate, and Justin. I'm going to spend a few minutes on the law, but the judge is the authority on what the law is, and she's going to instruct you what the law is. He's charged with 2 counts of involuntary manslaughter under 2 alternative theories. You don't have to find both. You don't have to agree on both. You can agree on both, but either one is the only thing necessary to return a verdict of guilty. The first is that there was gross negligence in the performance of a lawful act, and that the defendant caused death, and in doing the act that caused death, he acted in gross negligence. And then the second is his failure to perform a legal duty, and that he knew about the facts that gave rise to the duty, and he willfully neglected or refused to perform that duty, and he failed to perform it, and it grossly negligent to human life. And that the death of the victims were directly caused by defendant's failure to perform this duty. 4 counts of involuntary manslaughter for children who were killed. There can be more than one cause of death. James Crumbley doesn't get a pass because somebody else also caused the death of these 4 kids.
I fractured fairy
And
tale.
the judge will instruct you on that. It's not enough that he just made it possible for the deaths of Madison, Tate, Hannah, and Justin. You must find beyond a reasonable doubt that the deaths were the natural or necessary result of his acts or failure to act. You heard the evidence about how each of those kids were killed. And as previously noted, there can be more than one cause of death. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that his son's act of shooting someone was reasonably foreseeable. Not that he knew his son was going to kill 4 people. That is not what I have to prove. Just that it was reasonably foreseeable. What's gross negligence? It's more than carelessness. It's willfully disregarding the results to others that might follow from an act or failure to act. And in order to find that, you have to find that the defendant was grossly negligent, and you must find each of the following three things beyond a reasonable doubt. First, that he knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring someone else. Second, that he could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another one to a reasonable person. And it must be apparent that the result was likely to be serious injury. In Michigan, a parent has a legal duty to exercise reasonable care to prevent the minor child from intentionally harming others or prevent the minor child from conducting themselves in a way that creates unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Even before we had safe storage, there was always a legal duty that existed. That newly passed law has no bearing on your legal duty that as a parent that you've always had. I said this before, there are two theories, two different ways to prove the same crime. If proven, one of these, both of them, are sufficient to establish the crime of involuntary manslaughter. And again, it's not necessary that you all agree on which theory has been proven, as long as you agree that the prosecutors proved at least one of those theories beyond a reasonable doubt. I want to stop before I talk about the evidence briefly. I want to note that everyone appreciates how much care and patience you've taken in listening. It's clear and it's obvious, and I thank you for doing that. There are people, though, who think that the prosecutor's job is just to convict people, and that's just not true. It's our job to present you with the facts and tell the truth and to be advocates, and telling the truth sometimes involves showing you things no one wants to see. Sometimes our job requires to produce evidence and testimony and pictures and images that we don't want to show you and no one wants to see them. But that's our job. That's my job. And it's not our job to sanitize, even though that would be easier. It's my job, and it's Mr. Keith's job, to present all the evidence to you and explain why we think the defendant is guilty beyond a reasonable doubt. Mark Keith told you when this trial started that any number of tragically small efforts could have saved the lives of 4 kids, that it was foreseeable and it was preventable. And the evidence presented in the last 5 days has proven that, ladies and gentlemen. James Crumbleigh was presented with the easiest, most glaring opportunities to prevent the deaths of these 4 students. And he did nothing. He did nothing. He did nothing over and over and over again. And the evidence shows that. This case is not about holding James Crumbleigh responsible for what his son did. Again, if he knew exactly what his son was going to do, he'd be charged with murder. It's about his legal duty and his failure to perform it, or to perform it in a negligent way. You heard the testimony of Molly Darnell. She told you that the first thing she saw when she looked through the window and saw the gun being raised towards her was that there was no orange tip.
Hey,
Which she had
harlot
learned
and anonymous.
previously, she doesn't remember where, meant it's a real gun. That he aimed the gun at chest level and he locked eyes with her and the bullet landed 6 inches from her heart. Ed Wobrowski, who was a member of the computer crimes unit in the Oakland County Sheriff's Office. He told you about what forensic evaluation of cell phone analysis is. He was qualified as an expert. He described his involvement and observations at the school that day. And he told you that he doesn't really respond to incidents like this. He was in computer crimes. No one comes into the office and says you have to respond to a critical incident, except that day. And you could tell that that had a great emotional impact on him. He watched hours and hours and hours of videos and images of that school that day to put together the evidence that we were able to present to you today and through the past 5 days. He reviewed all of it and he described and then showed you the path and the camera angles of the shooter's path through the school that day. He also presented the messages between Jennifer and James Crumbleigh and the messages between their son and his friend. He told you that there were over 20,000 text messages between the shooter and that one friend he had. He also told you in 1 year, there were only 65 text messages sent between James Crumbleigh and his father. James Crumbleigh, who had either worked at home, was in between jobs, or had DoorDash. James Crumbleigh, who was the person he dropped his son at school every single morning. He told you that the image of the gun that the shooter shared with his dad was deleted. We played the voicemail from the school on November 29th from Pam Fine, talking about his son searching bullets. He presented evidence that he was aware of that because Jennifer told him about it. She texted, "Did he tell you about what happened at school?" James responded, "Yes." He shared with you the defendant's communications on November 30th of 2021. And important to note, he was able to show you exactly the path that he took. Because of the cell phone data, some of you were probably surprised and a little concerned where he was, what he did. He showed you through the DoorDash search warrant returns the locations of what James Crumbleigh was doing from the moment he left the school that morning until the moment he called 911. And only after he learned that there was an active shooter at the school did James Crumbleigh go home and look for the gun. Even though from 11 o'clock to 1 o'clock, he had 4 DoorDash pickups and passed his house many times. He was within minutes, many times. And you heard the 911 call by James Crumbleigh about 14 minutes after he arrived home and discovered that the gun was missing. Bob could tell us, he testified, and we showed you images of the hallway in that school when he processed the scene. And you saw pictures of that. And he told you that a total of 50 fired and unfired cartridges were recovered. And that the shooter fired 32 rounds and 18 were unfired. And we know where he got those 50. You saw that. It's when he pointed them out across the counter when he's with his mom standing a little bit behind her and said, 2. And you also know that James probably knew that because when he was at the substation and they asked about where this gun was, who owns the gun, where's the ammo, he described it as he bought 2 boxes, referring to his son. Bob Catellus told you that those are rods placed in where bullet holes have penetrated that glass. And as you can see, and you saw other images, this was somebody who knew how to use a firearm. And Special Agent Brandon told you that's immediately what he observed. Those are shots, if landing on a human being, would kill them. Cami Batt explained in detail what her requirement is and what she did that day, and that she knew James Crumbleigh because in June he came in and he bought 2 more guns, one for himself, which the evidence showed, because he told Jennifer how much did your gun cost? It was $300, and then there was another gun, which was his son's, a Derringer, and you saw the Derringer. She told you that she also sold him the 9mm on the 26th, that his son was present with him. He stated he's had his eye on that gun. She told you that they sell a locking mechanism with each gun they sell, that he was provided the trigger lock statement, and that there was a cable lock with the Sig Sauer when he bought it, and it was provided to him, and the ATF pamphlet solely in existence to just warn people, once again, the dangers of firearms with minors. And she told you that regardless of what kind of mechanism they provide, they always try to provide a tool with anyone who purchases a firearm to make it safe. Sergeant Joe Bryan testified and introduced the video, the recorded statements of James in the substation. James' statements indicate he knew that his son had only one friend and that he left abruptly. He referred to the math worksheet that morning as some doodling on a paper. But that was after the shooting. Before the shooting, we know that he texted Jennifer Crumbley, WTF, when he saw it. Now he's downplaying it. It's just doodling. When asked how many rounds, he corrected Jennifer and indicated there were a box of 50 rounds that he bought his son. When asked where the gun was, James responded, it was hidden in an armoire, in the case, and the bullets were hidden in a completely different spot underneath some jeans. We're gonna get to that. What James didn't say that day, no mention of any lock. No mention that the school wanted them to get their son help that day, and then when they couldn't, within 48 hours. And here's something you never hear him say. You hear him say the gun was hidden. You hear him say that there was some doodling on a paper, that he was a perfect kid. But here's what he never says. He never says, I don't know how he got it. Never said that. He never says, it was hidden. I have no idea. I can't imagine how he got a hold of this gun. Never mentions that. 4 kids just died. Your son's in custody because he committed a school shooting, and not once do you say, how did he get the gun? And you know why he didn't say it? He didn't say it because he already knew. He knew his son had access to the gun. Christy Gibson Marshall, as we just talked about, heard gunshots, saw kids running in a way that wasn't normal, went towards the shooting, identified and spoke to James Crumbley's son, and you saw that video, how she just stood there. Sean Hopkins. Sean Hopkins was a counselor. He testified that the shooter was looking up bullets the day before. He was aware of that. That morning he was told he was watching violent videos. And he told you that even in a 20-minute period of time, he was concerned enough to call parents and ask them to come to school right then. He told you that he said he needed help right away. He wanted them to get him some help right away. He told you that he was very concerned about the images, but his main concern was for the safety of the shooter. He told you he didn't want him to be left alone. And he said in that meeting, he never received relevant information from mom and dad. It was short. It was a very, very small period of time for a meeting that takes place when you have to come from your work. James was at the barn at the time. Go to your son's school. They were in and out of there in a very short period of time. He testified, they said that just couldn't happen today. They had to work. Now, you've heard the testimony. You know what James Crumbley was doing as employment during that time. And defense counsel and I agree. That is a worthy endeavor, being employed regardless of how you choose to do it. But what's important to note is that DoorDash is not something that you can create your own hours. You can work when you want. It's not compulsory. You can work on the weekends. You can work anytime. Nick Ejak is the Dean of Students, testified that he was also at the meeting and that James Crumbley seemed irritated. And that at the time they knew only a fraction of what was going on. No one told anybody at the school, they just purchased him a gun. Nobody, neither one of them, James Crumbley didn't say, you know what, we had this fight before, they mentioned about the fight the night before about grades, but didn't really discuss it as a big deal. Didn't really discuss the gravity of what it was like for his son, who had one social connection to the outside world, and that person abruptly left with, and that his son found out because he just stopped texting him back. And that he was obviously so concerned and upset that he communicated that to his father because his father reached out to the friend's father. He didn't say that. He didn't say that the weapon wasn't secure. He didn't say that there had been signs that something wasn't right. Now, you may not like what the two people who were employed by the school and had contact with the Crumbleys that day did. You may not like it. I don't like all of it either. But my job isn't to present to you the evidence that just looks good for my case. My job is to present evidence to you, all of it, because this is about the truth. But he doesn't get a pass because you don't think the teachers did enough. He doesn't get a pass for that. And the blame shifting is only meant to send a message, I'm not accountable here at all. Even though I bought the weapon, even though I didn't secure it, even though I never got help from my son, even though I could have taken him that day. Special Agent Brandon testified where he was when he heard about the shooting, what he did when he got to the school, how he traced the gun, how he found out who owned it. He watched the surveillance. He noticed a couple things that were really concerning to him. One, it was somebody who was proficient with a firearm. He did what's called a combat load, which is unusual. The way his stance was, the shot he took that killed Tate. This wasn't somebody that wasn't experienced with a firearm. And logically, he wanted to know where this person was taught how to handle that weapon, where that minor was taught, that 15-year-old. And he discovered that. He testified that the cable lock that was seen in pictures was sold with the SIG, and it was the cable lock that was seen in the photos. And then he testified that they found that cable lock shoved in another gun box in the kitchen in a cabinet behind a door. You also heard him tell you that the minute he looked at that drawing, he instantly noticed the gun. It wasn't just any old gun. It wasn't. And maybe you wouldn't have picked that up. But Special Agent Brandon did. And you know what? Who else would have known? The person that purchased the gun, James Crumbley. Detective Stoyak talked to you about the search. You saw pictures of the search and the house. You saw where the gun box and the ammo box were when they searched the house. It was on their bed. You also saw a map and learned a pretty small house. Pretty small. You learned he had 2 bedrooms. And you learned that in that master bedroom, which was small, there was the bed, some nightstands, and 2 other pieces of furniture. The TV stand, where he found the 2 other weapons that were in a gun safe, a locking mechanism with the code set to 000, which is the default. Detective Stoyak and told you what others did. He never, ever, ever said that SIG was locked. He said it was hidden. David Hendrick is in charge of the fugitive apprehension team. You learned what that is from 2 law enforcement officials. You learned that on the day the defendants were charged, they left a hotel in Auburn Hills, local, and drove all the way to Detroit in a building that is meant for businesses, not retail, people don't sleep there. And you heard what it was like when he arrived on the scene, when they were searching for James Crumbleigh and his wife. You heard through the body cam of the Detroit officer, and you heard from Officer Hendrick, and you heard from Luke Kirtley that it was extremely loud. There were dozens and dozens and dozens of law enforcement, and most of them SWAT. Luke Kirtley told you about how James Crumbleigh was discovered that night. And the only reason he knew it is because it was all over social media with the description, the license plate, and a picture of James Crumbleigh and Jennifer Crumbleigh. Why? Because they were charged. And even before they were charged, there was a lot of speculation about them being charged. Luke told you about what that building looks like, what it's for, who's normally there at night, not many people, that he shares a wall with that studio that they were found in, that mattress they pulled in was out in the hallway. He again told you how loud, and that it would have been impossible if he was in his unit not to hear that. Officer David Metzke told you that there were tons of officers, multiple agencies, and that they took a 35-pound steel ram to bypass multiple doors, and they used it, and it was loud. I think he testified we have the bigger guys do that. We saw through his body-worn camera the arrest of James Crumbleigh, who was laying on the mattress and seemed to be wanting to create the impression that he was sleeping. There's a big problem with that. One, we know that shortly after Luke Kirtley went out to see the license plate, that he followed him shortly after, and he was away. And shortly after that, dozens and dozens and dozens of law enforcement show up on the scene. It's a first floor unit. The windows face that parking lot. Lights and sirens, media were there, yet he's lying on a bed as if he's sleeping. William Creer told you what they discovered. They had bought and purchased, they had purchased items with them, socks, new socks. They had clothing, they had food. There was a whiskey bottle in the trash can. There was ice. But here's the thing that was the most compelling about his testimony. The bag with the 4 phones that were turned off and $6,000 of cash was stored on the other side of the room from the backpack in a lid in a plastic bin with a lid on it. That is strong circumstantial evidence, which is used in this country every day to convict people, that was placed there in hopes that no one was going to find it. $6,000 cash, 4 cell phones turned off, which is odd if you're really trying to get up in the morning and go somewhere, and the alarm was set on one of those phones, but they were off. But what did Ed Wobrowski tell you? He told you that you can't track a phone if it's off. You can't track it. We all learned, if you've learned nothing else, turn your phone off if you don't want to be tracked, because there's all sorts of ways. Lieutenant Willis testified. He showed you the bank records showing what they did when they found out that their son was charged and when there was talk of them being charged. He talked to you about the scene at Oxford High School. And it was a really detailed description of what it was like in that school that day. Because hundreds and hundreds of law enforcement officials went to that school, some miles away. No one asked them to. They just drove there from all different parts. And so it was Tim Willis's job to take all of those people who wanted to help and give them something to do and get the scene processed and start building a case. And answering questions, which is really what an investigation is about, way before you get to a prosecutor. Because sometimes you never get to the prosecutor. Your job is to go where the evidence leads you. And there were things about this case from the very beginning that just seemed like questions that needed to be answered. And one of them was that gun was purchased 4 days earlier by James Crumbley, who was the same person who was at the school that day. This is information they're learning immediately. They do a search warrant for the house and for phones, and they find out a lot of information. You saw the video of the shooting. There's a reason we tell the media they have to turn their cameras off. We don't want those images out there. We don't want them to be on the internet. We don't want to encourage another school shooter. And we don't take any pleasure in showing it to you. But it's our job to know the truth and look at it and not look away. He told you how each of those kids died. Hannah was hit immediately after he left the bathroom. You saw the image and it was described to you. Madison Baldwin didn't run. She crouched down. There was a door 4 feet from her. And she put her hands over her head. And he walked right up to her and he shot her at close range in the head. Tate was shot. I talked about that shot he took as he was coming in the door. He had his headphones on. He didn't even know what was going on. And Justin Schilling was shot in the bathroom after several minutes of being in there. It wasn't immediately. Shooter went into the bathroom, stayed there. Justin knew the shooter was there. And there was another student in there as well. You saw him running, Keegan. And he ran after James Crumbley's son shot Justin Schilling, execution style. Defendant's son had access to and the use of this gun. It was preventable and it was foreseeable. You heard during jury selection and you heard during opening, and if my prediction is you're going to hear it again, that this could be you. This could be any of us. This is what this is their defense, that this could be you if you let your kid drive a car or leave with a sharp object. This couldn't be everybody. This couldn't be the person that takes their kid hunting. This couldn't be the person that buys a gun for their child to use, for their minor child, for their use. That doesn't create a criminal charge, ladies and gentlemen. It couldn't happen simply because you purchased a firearm or simply because you let your kid drive a car. Beware of the claim that this could be you. Beware. It is not the case that finding James Crumbley guilty of gross negligence would result in a criminal charge for every parent who doesn't know what their child is doing at all times. And it is not the case that he was faced with the same normal challenges as parents that we all go through and suddenly found himself in a courtroom being charged with involuntary manslaughter. It is just not the case, and the evidence shows it. In June, the Derringer and the Caltech were purchased by James Crumbleigh. We know that Caltech was left out, unsecured, with ammo. Why do we know that? You saw that picture and video and the one he sent to his friend, and you saw the text that accompanied. But before we get to that, this is an image from the video that you saw. It was 12:30 at night. That is his cat, Dexter. That is the shooter's cat. That magazine is loaded, and it was shoved on a table to load it, not a proper or safe way to handle a firearm. And there is a round in the chamber, and the safety is off because red means dead. And Special Agent Brandon told you that. Even if James Crumbleigh was standing next to his son, that would still be an extremely dangerous way to handle a firearm. But we do know what happened, because he told his friend when he texted it to him. My dad left it out, so I thought, why not? This is precisely the reason there's a legal duty in the state of Michigan to prevent your kid from harming himself or somebody else. All I need is my 9mm pistol, which I currently am begging my dad for. This is from his journal. First off, I got my gun. It's a Sig Sauer 9mm. Second, the shooting is tomorrow. I have access to the gun and the ammo. I have access to the gun and the ammo. Then we have defendant's own statements. James Crumbleigh said at the substation, James responded when it asked where the gun was. It was hidden in our armoire in the case, and the bullets were hidden in a completely different spot underneath some jeans. Here's what he doesn't say. Never claims it was locked, never says it was inaccessible to his son, and again, never says or expresses any surprise on how his son got a hold of it. We know he took him to the range. We showed you videos and images of that. In fact, 8 times we know that happened. We know that throughout June, July, August, September, October, by November, when he begged his dad for the 9mm, and he actually did buy it for him, now he's at the point where he can instruct other people. It's James Crumbleigh's son that knows more about guns and when he takes his mom to the range. And how did he learn? James Crumbleigh taught him. He didn't take himself to the range with his dad. This is the shooter 2 days, 1 day after the gun was purchased for him. He's packing it up. What don't you see? The cable lock. It's not even in a case anymore. And there it is. That's the cable lock that was provided that day with the pamphlet and with the gun. Just the day before. It's already out of the case. Here's where the other 2 guns were found in that bedroom, in defendant's bedroom, in a safe. In the TV stand. The code was 000. The important thing is that the SIG could not fit into that gun safe. Could not fit it. It's impossible. But the other important thing is you're hearing a claim that James Crumbleigh didn't think that he had to lock his weapon up. Okay. It's not about whether you lock the weapon. It's about whether you made it secure. And we already know he felt the need and understood his duty to lock the other 2. Special Agent Brandon read to you the lines, if he had opened it up, if he had read it, if he had believed it, those deaths could have been prevented. If he had just read it and just did the simplest of things. This is the crime scene. There were 32 shots fired that day by James Crumbley's son. How do we know this was foreseeable? The shooter says in his journal, I have zero help for my mental problems, and it's causing me to shoot up the fucking school. You heard a lot during jury selection and opening about kids exaggerate to their friends. This is his journal. He's not sending it to a friend. He's expressing his state, which was desperate because he needed help. I want help, but my parents don't listen to me, so I can't get any help. My parents won't listen to me about help or a therapist. I can't even say with a straight face or even find a way to explain the rationale behind a 15-year-old that desperate writing that in a journal because he was exaggerating or lying. We have the text between James Crumbley's son and his friend about exactly what he wrote about in the journal. He hears people talking to someone in the distance. I actually asked my dad to take me to the doctor yesterday, but he just gave me some pills and told me to suck it up. Again, teenagers exaggerating to make themselves look better, to impress. None of these text messages to his friend make him look better. None of them make him look impressive. They just make him look desperate and sad and wanting help. I'm having bad insomnia and paranoia. I need help. I was thinking I could call 911 so I could go to the hospital. This was in April. But then my parents would be really pissed. I'm going to ask my parents to go to the doctors tomorrow or Tuesday again. But this time I'm going to tell them about the voices. And then on April 5th, like I am mentally and physically dying. What did James Crumbley know? He knew the family dog had died. A grandmother had just died. His son's only friend, the one person he had any social contact with, abruptly leaving, can't even text him. Knew his son was completely isolated. Knew he had looked up bullets the day before. Knew he was upset the night before. Knew he had been watching videos that morning, violent videos. And then he sees that drawing. He sees that drawing that morning when he goes to the school, and what does it say? It says, help me. How many times does this kid have to say it? He says it in his journal, he says it to his friend, and what is he saying? I asked my parents, I asked my dad. And then if that isn't enough, he writes the words, help me, on a piece of paper. And his parents, James Crumbley, is called to the school to see it. And what does he say? He says, we gotta go to work. He describes his son as a perfect kid, never gets in trouble. Well, you know, if you have a perfect kid that never gets in trouble, being called to the school abruptly that day and asked to come and saying your kid needs help is about 100 out of 10 in terms of how troubling it is for a parent, if it's that unusual. He knows his son is proficient with guns because 4 days earlier, he purchased that weapon for him. This is James Crumbley's son on the morning of the shooting, November 30th, being dropped off like every day by James Crumbley. And here's the worksheet. The thoughts won't stop. Help me. You have a picture of someone bleeding with bullet holes. You have a picture of the exact gun. It says blood everywhere. My life is useless. The world is dead. This is the worksheet James Crumbleigh looked at when it was texted to him. This is the worksheet he sat and looked at when he sat in that counselor's office. Those are the words he was reading when his wife said, "We can't do that today. We have to work." And he said nothing. And he leaves with a piece of paper with the names to call. This is what he was looking at. And there's the piece of paper. It took just one tragically small measure of ordinary care to avoid 4 deaths. James Crumbleigh failed to use ordinary care, which could have prevented the death of these 4 kids. Didn't stop at home to check to see where that gun was. Even though you can't take him, which we know he could have driven around with him. He could have not done any DoorDash round until Jennifer comes back from work. He could have gone to see where that gun was. We know that in his DoorDashing, he was minutes away from 11 o'clock to 1 o'clock. He didn't search or ask to see the backpack, never thought then to say, "Hey, can I talk to you out in the hall?" Or, "Hey, where's that gun?" Didn't ask his son where that gun was, didn't check the journal, despite acknowledging he had one, didn't lock and secure ammunition, didn't lock or secure the gun, didn't take his son home, didn't take him to get this care that a counselor's telling you he needs, didn't say, "We bought him a gun 4 days ago as an early Christmas present," and didn't tell the school much relevant information at all, and Sean Hopkins told you that. He also didn't disclose any of the instances that you were shown throughout this trial. That there was a message in March about him doing something stupid. Jennifer Crumbleigh was concerned about it. James was always home. "Is he home yet? Is he home yet? Is he home yet? Leave me alone, I have to work. He's fine," is what he says. The incident about giving him melatonin and him being worked up, didn't tell him that he'd asked him for help and asked to go to the doctor, told him to suck it up. Didn't say about the friend and how it was his only person he ever had any social contact with, that there were multiple guns in the home, that he was begging for a 9mm. James Crumbleigh never even shot that gun. He didn't fire it once. He had it, he purchased it on Friday. On Saturday, he was gone all day doing DoorDash. On Sunday, he was gone all day doing DoorDash. And that he wants you to believe he had this secure hiding spot. What, it was a hiding spot for 1 day? We know it wasn't there on Saturday. We had the shooter taking pictures of it. And we know the cable lock isn't around. And we know Jennifer leaves. He's alone with his gun. Didn't say that it was identical to the one in the drawing. Didn't say he bought 50 rounds to take home, expensive rounds to use at a range. This is the DoorDash information from 11 o'clock to 1 o'clock and all of the times he passed that house. He was within minutes. We know that he was absolutely concerned about this worksheet until after the shooting in the substation where he says it was doodling. We also know that not once on any of his devices did we find any searches or information he was trying to get about firearm safety or how to make sure a minor doesn't get a hold of it, laws, any of it, until after the shooting. We know that at 10:37, he arrives at school. His son leaves at 10:52. They're gone by 10:53. At 11, he logs on to DoorDash. He completes 4 orders. He tells us in the 911 call and at the substation, he saw cop cars. We know that 12:51, the shooting starts, and we start to see students and parents, we heard, arrive at the Meijer. They're being told by dispatch that's where the reunification time is. James drops off his last order at 1:01. The email comes out from the school at 1:09. At 1:11, James is in the Meyer parking lot. It's unclear exactly why. He calls his wife for 57 seconds. That's the call lasts 57 seconds. He's on the phone with her for 10 minutes and 19 seconds. He gets home at 1:20. During that call, she texts her boss, the gun is gone and so are the bullets. So we know that by 1:23, both of them had knowledge about that. He calls her again, 1:30 to 1:33, another 3 minutes, and finally calls 911 at 1:34. There were 1,800 students in Oxford High School. There was one parent who suspected their son was the school shooter, and it was James Crumbley. You know what that's called? It's called foreseeability. That's what that's called.
What's the location of your emergency? Okay, I'm not really sure. I'm at my house. There's an active shooter situation going on at the high school. My son goes to high school. I have a missing gun at my house. I need an officer to come to my house right away, please. Okay, I'm not going to be able to send anybody to your house right now. So they're on the active shooter situation. I understand that. There's a million out there. I have a missing gun, and my son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper, and then I was down and I saw a whole bunch of cops going somewhere, and I made sure that I wanted to get to the hospital, so someone was going to the hospital, and then somebody told me that there was an active shooter, and then I raced home just to find out. Okay, and I think my son took the gun. I don't know if it's him. I don't know what's going on. I'm really freaking out. My son's name is Ethan Crumbley, C-R-U-M-B-L-E-Y. C-W-Y. All right, sir, I'm going to put you on hold for just 1 second, okay? To Dr. Cookman, come in and see if I can do anything for you, okay? We'll put you on hold. Thank you. Okay, good.
You just heard this. I have a missing gun. My son is at the school, and we had to go meet with the counselor this morning because of something that he wrote on a test paper. And then I saw cops going somewhere. I wanted to go to the school, see what was going on. I heard about the active shooter, and I raced home just to find out. We don't have to discover or argue about whether or not he was put on notice that something was really, really wrong. He says it. He says it. He calls and he says, because of this meeting at the school, and because I have a gun, I went home to look for it when he heard about the shooting. So the question of whether or not that did concern him, it's not a question. We know it concerned him because he said it. And then at the substation, and this is what he said, and somebody said there was an active shooter, I immediately freaked out because the situation. And after I saw all the cops, after I found it was an active shooter that went on this morning, and after what went on this morning, what's he talking about? He's talking about the meeting and the words on the paper that says, help me, blood everywhere, with a picture of the gun he got him. So I raced home and I found the gun missing. We went into detail about what James Crumbley and his wife did after they thought they might be charged with a crime. And the evidence clearly shows what they didn't do. They did not turn themselves in. They did not make sure that they were in the area. They withdrew $6,000 and they went to Detroit and turned the car around so the license plate is not facing, and didn't go out and buy that stuff themselves. They sent somebody else. And lastly, defendant conflicts his own statements. At the substation, the drawing was doodling. When he receives it from his wife, he's concerned, my God, WTF. He says at the substation, I immediately raced home and found the gun, and that's when I called you. I called you guys right away. It was 14 minutes after he got home. You think your kid has this gun, you know he does. You know he's really upset, you know the words he wrote, you suspect he's the shooter, and you wait 14 minutes to call 911? He doesn't know when the shooting started or when it ended. I think you owed something to the parents and the kids in that school to at least try, once he did figure out that the gun was gone, which any reasonable person would have known. But why lie and say you call right away? You called after a 10-minute conversation with your wife. At the substation, he's a perfect kid, doesn't get into trouble, yet he was looking up bullets, and yet they were called to the school and the drawing. He doesn't say that, or what the drawing was really about. It's a downplaying situation, and then he says the gun was hidden. And again, never once, I don't know how he got it. Never once says that. James CRUMBLEY had concerns that day. He knew something was wrong. He said it in his own words. And we know that because of what was on the drawing, and we know that because we know what his response was when he received the drawing. He kept those concerns private that morning. But he didn't just fail to inform the school. He failed to act. James CRUMBLEY failed his son in a tragic way. You're not going to hear me say that's not true. But he didn't just fail his son. He failed Hannah. He failed Madison. He failed Kate. And he failed Justin. He failed to perform his legal duty to prevent these kids from being killed. And he failed their parents too. And I ask that you find him guilty. Thank you.
Thank you, Prosecutor. Ms. Lynn?
Yes, Your Honor.
There were a variety of emotions following the shooting on November 30th of 2021 at Oxford High School. Terror, anger, and devastation. There's an epidemic of mass shootings in our country. School shootings in particular have devastated our communities. There have been social and political groups formed to address these issues, but so far they've been unable to do so. However, on December 3rd of 2021, the parents of a school shooter were charged with involuntary manslaughter for the first time. When we started this trial, I said that the events of November 30th of 2021 undeniably changed people's lives in ways that most of us will never understand. We know that 4 children were killed, multiple families were devastated, and communities were terrorized. And ladies and gentlemen, James CRUMBLEY and I do not dispute any of that. We heard from people who were at Oxford High School on November 30th of 2021. We not only heard what they had to say, we saw the impact that day had on them. Multiple people told you what that day was like. They told you what they felt. They told you what they saw, and they told you what they experienced. You were also shown videos of what happened inside of the school on November 30th of 2021. We can agree that you all heard a lot about what happened inside of Oxford High School on November 30th of 2021 through videos and testimony. This case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. This case is about what James Crumbley knew on and before November 30th of 2021. James Crumbley was charged on December 3rd, 2021 for the deaths of Hannah St. Juliana, Madison Baldwin, Tate Meir, and Justin Schilling. As you've seen throughout this trial, the charges and allegations against James were based on assumptions and hindsight about James and his knowledge about his son, who we've referred to as either his son or the shooter. The prosecution is asking you to second guess the decisions made by James Crumbley on November 30th of 2021 and before those days. And as Sean Hopkins told you, it's easy to look at things in hindsight. But we aren't here to look at things in hindsight. We are here to look at what James Crumbley knew prior to and on November 30th of 2021 before the shooting began. You heard no testimony and you saw no evidence that James had any knowledge that his son was a danger to anyone. You heard no testimony and saw no evidence that James Crumbley knew what his son was planning. You heard no testimony and saw no evidence that James Crumbley was aware that his son knew where the firearms in the home were hidden. You heard no testimony and saw no evidence that James Crumbley was aware that his son had obtained access to those firearms and had handled them unsupervised. Still, the prosecution wants you to find that James could foresee that his son was a danger to others and that James acted in a grossly negligent manner or breached a duty that he owed to other people despite having no information at the time. You obviously know that the defense has no duty to present a defense. We talked about that during jury selection. The judge will give you instructions on that and the law on that. But we did bring out more information so that you all had a more full picture, a more complete picture of what happened in the days leading up to November 30th of 2021 and even on November 30th of 2021. But in the end, if you have any questions, if there's anything that you're unsure of, if there's anything that you're wondering about, the prosecution was the only one that had a burden of proof. When it comes to burdens of proof in this country, beyond a reasonable doubt is a very, very high burden. In civil cases where people sue each other for money, the burden of proof is 50-50. Preponderance of the evidence, whether or not somebody gets money and somebody has to pay money. In cases where the state wants to take your child due to abuse and neglect, it's clear and convincing evidence, a little bit higher. Beyond a reasonable doubt is the highest burden in our country, the highest burden of proof as it relates to criminal prosecutions. Judge Matthews is going to instruct you that reasonable doubt is just that, a doubt based on reason and common sense. It can be based on the evidence, or it can be based on the lack of evidence. When it comes to reasonable doubts, you can have one or you can have 10. You don't have to have the same reasonable doubt as your neighbor. What matters is that if a juror has a reasonable doubt, then they must vote not guilty. You can believe that if the prosecution had evidence that James Crumbley knew that his son was a danger to others, you would have seen it. Especially if James knew what was inside of that journal. We've heard about the journal. If James knew what was in that journal, the prosecution would have told you that. If James knew that his son had gained access to his firearms, the prosecution would have told you that. You definitely would have seen it. And the fact that you have not seen any of that evidence can be your reasonable doubt. You can also believe that if the prosecution knew that James Crumbley knew that his son knew where the firearms were stored, the prosecution would have told you that. You would have heard about it, but you didn't, because James didn't know. He didn't know that his son knew where those firearms were. Absence of evidence that James knew that his son had learned where those firearms were can be your reasonable doubt. Also, if James had violated any laws as it relates to storage, specifically gun storage, you would have heard about that, but you didn't. In fact, you heard from ATF agent Brandon, who told you there are multiple ways to store a firearm. Multiple ways. You can use a safe. You can use a cable lock. You can use a trigger lock. You can store it unloaded with the ammo separately. You can store a firearm in any number of ways. That came from ATF agent Brandon. Those were his words. If the prosecution had evidence that James knew that his son was accessing firearms without his permission, not that his son was accessing them without his permission, that James knew that his son was accessing them without his permission, the prosecution would have shown you that. But you didn't see it because it isn't true. James didn't know. This can be your reasonable doubt. Mr. Wagrowski testified that James would have heard his son handling the firearm, the Kel-Tec that you saw the video of, where he sets the Kel-Tec on the table and loads the magazine. He slides the slide forward. He releases the slide forward. Mr. Wagrowski testified from this chair that James would have heard that because of the volume of the sound and because of the size of the home. You all have observed James throughout this trial. You've seen him. Judge Matthews instructed you at the beginning, James is wearing headphones. James is hard of hearing. He needs a hearing assisted device to hear, even in this courtroom. And if you watched, there were points where he had to push the headphones into his ears so he could hear better because he still couldn't hear well enough.
Your Honor, I hate objecting in a closing, but that is not evidence, and her client didn't testify. And so it's just not evidence what he was doing. And it's just not. And his headphones are not evidence.
There's evidence that he needs a hearing device, as I explained to you in the beginning of the trial why he was wearing those headphones. Go ahead.
Thank you, Your Honor. Mr. Wagrowski also testified that he could not indicate and could not say with certainty where James was at the time that his son made that video. He knew that James was likely at the home. He didn't know if he was outside in the very large backyard that Detective Stoyak told you about. He didn't know if he was in the home. He didn't know if he was standing next to him. He didn't know if he was standing outside. He didn't know if he was in another room. He didn't know if he was sleeping. Mr. Wagrowski couldn't tell you what was going on other than James Crumbley's son handling that firearm. Was it unsupervised? We don't know. Was it supervised? We don't know. We don't know. So any statement by Mr. Wagrowski that James had to have heard that is an assumption. It's not based on fact, and it's not based on evidence. If the prosecution had evidence that James was concerned about his son's mental stability, or if his son had asked him for mental health treatment and it was denied by James, you would have seen that. Not a statement by his son to a friend or a writing in a journal, a statement by James that he acknowledges that his son was having issues, that his son was having a hard time, that his son needed help. None of you saw that. None of you saw that because it's not true. James had no idea that his son was having a hard time. Instead, you saw text between James's son and his friend in April of 2021, where his son says he's going to tell his parents about the issues he's having. You also heard testimony from James's sister who said she saw him within a day or two, maybe 3 days, of those texts being sent to his friend in Florida after their mother passed away. James and his sister's mother passed away. She spent a week or a week and a half and saw James and his son, and saw no concerns, not worried, didn't hear anything, didn't see anything, wasn't made aware of anything, no concerns. You heard that on November 30th of 2021, James drove his son to school. You saw the video of James dropping his son off. You heard that later when James went to the school with his wife to meet with his son and the school counselor, Sean Hopkins, and the dean of students, Nick Ejak, that James had told them, or that James had had a conversation that he had talked to his son that morning, told his son he loved him. We just want you to do your schoolwork. We want you to do your best. There was never a conversation about, Dad, I'm having a really hard time. Dad, I really need some help. In fact, there were no concerns expressed whatsoever. James had no knowledge that there was an issue. You also heard Sean Hopkins and Nick Ejak both testify that in the office, sitting in the office, that James sat next to his son, right in front of Sean Hopkins' desk. Sat next to him, went over the piece of the math assignment with him, the drawings, what was on there, that he was caring, that he told his son, you can talk to me. You can talk to other people. There was some reference to a journal. There was no indication that James knew what the journal looked like, whether or not his son was even writing in a journal, where it was, how often he used it. No indication at all, just that one may exist. And again, in that meeting, there were no comments, whether either before James got there or after he arrived, from James's son to the school counselor or the dean of students saying, I really want some help. I'm really having a hard time. I really need to see someone. I've been trying to talk to my parents and they haven't been listening to me and I need you to tell them. That didn't happen. Instead, Mr. Hopkins testified that he had concerns about the level of although appropriate, the level of sadness that James's son was experiencing. Sadness associated with the losses that he'd had that year. He lost his grandmother. He lost their Great Pyrenees dog. His friend moved away. He had a hard time with COVID. He struggled with virtual school. Mr. Hopkins was concerned about the sadness and wanted James's son to see someone to ensure that it didn't get any worse. Not that he had to see someone right now. It's an emergency. He has to see someone right now. That's not what was said. In fact, if you recall Mr. Hopkins' testimony, and I believe Mr. Ejak said the same thing, that James and his wife were told that the school was going to follow up with them within 48 hours. Now, in Mr. Hopkins' head, he testified he was thinking it was going to be the next morning, but he told them 48 hours. You heard Mr. Hopkins testify that James's son said he wanted to stay in school. In fact, he even asked for his homework while sitting in the office waiting for his parents. He asked for them to go get his homework. So they went and got his backpack. They brought it back. He started working on schoolwork. His attendance wasn't bad. There's some question about whether or not he missed one or more days of school that year, but his attendance wasn't bad. His grades weren't terrible. They were average, according to Sean Hopkins. There were no concerns, even by Sean Hopkins and Nick Ejak, beyond the sadness that they saw James's son was experiencing. The absence of evidence that James knew about the struggles that his son was having can be your reasonable doubt. You heard from James himself more than once. You heard him tell the police that there weren't any issues with his son. Within an hour of the shooting at Oxford High School, James was at the police station with his wife, interviewing with law enforcement, talking to them, saying, my son was a great kid. I think he used the word perfect. That his grades were mediocre, again, although Sean Hopkins said they were average. But that he'd never had any disciplinary issues. Sean Hopkins and Nick Ejak confirmed that. They had no disciplinary history with James's son. And even if you have a question about how great of a kid James thought his son was, Christy Gibson Marshall said the same thing to you. We'll talk a little bit more about that. But Christy Gibson Marshall also said that James's son was a good kid. Christy said that her testimony was that she was standing in the hallway. She had spotted the shooter coming down the hall with a firearm, with a gun in his hand. She saw that there was an injured student in the hallway. She walked up to the student, was standing next to it. You saw the video. She's standing next to the student who's injured on the floor. The shooter gets closer and she realizes that it's James's son. And her first thought was that it couldn't be right. With a gun in his hand and an injured student in front of her, smelling cap gun, she didn't think that was right. Even in those moments. Going back to Sean Hopkins and Nick Ejak, two people who met with and talked to James's son on November 30th of 2021, at one point for over an hour without James and his wife there. They talked about a variety of topics. This was 2 hours before the shooting began. They said that based on the explanations that they were given about the drawings on the math assignment, that they weren't concerned. Kids draw violent things. Kids draw guns and bullets. That the confirmation combined with the confirmation from James and his wife about what was going on in their son's life, in combination with the explanations that they were given by James and his wife's son, that they weren't concerned. There was an explanation about interest in video game design. They looked a little bit about video game design. Sean Hopkins and Nick Ejak weren't concerned on November 30th of 2021, 2 hours before the shooting started. Both Sean Hopkins and Nick Ejak told you that guns are not uncommon in homes in Oxford. It's a hunting community. That it's not uncommon for students to handle guns in their homes or to go to the shooting range. That they knew that James's son had gone to the shooting range the weekend before with his mom and that he had access to a firearm. They didn't ask any more about this, about access to a firearm or having a firearm in the home, because they weren't concerned that James's son was a danger to anyone. They weren't concerned. Sean Hopkins and Nick Ejak testified that they had concerns related to the effects of the losses that James's son had experienced in that year. There was testimony that James's son's level of sadness was appropriate given various factors, but that it wasn't concerning. They just wanted to address it to ensure it didn't get any worse, because they'd seen sadness get worse and have issues with other students, according to Sean Hopkins' testimony. We talked about Sean Hopkins and what he said about wanting James's son to see someone within 48 hours. You also heard testimony from Sean Hopkins and Nick Ejak that they didn't believe that, or they believed that James and his wife were going to get their son help, that they had no reason to believe that they weren't going to. And if they did, they would have done things differently. If they had concerns that it had to happen right now, they would have done things differently. But they didn't. Sean Hopkins and Nick Ejak testified that they didn't ask if there were guns in the home. They didn't ask because they weren't concerned that James's son was a danger to anyone. Despite the information and the concerns that they had, they made decisions with the information that they had at the time and based on their education and training, which we can all probably agree, a school counselor and a dean of students has more education and training than the average parent. And even with all of that and the experience with teenagers and what they had in front of him, they still didn't believe that there was a reason to be concerned that James's son was a danger to anyone. In fact, they didn't even feel that he was in immediate danger to himself, because if they had, they testified they would have done things differently. James worked. You heard the testimony. He left the school at approximately 10:57, and if you want, you can go back to the exhibits, and logged on to the app for DoorDash and started working within 3 minutes. The prosecution is focusing on James not going home in the time from leaving the school and when the shooting started. Why would he? He didn't know. He didn't know what was going on with his son. He didn't know what his son was planning. He didn't know that his son knew where the guns were. And he didn't know that his son had somehow obtained access to those guns or a gun. He didn't know. So why would he go home? There was no reason to. You heard about James's actions following learning of the school shooting, or following the school shooting. You heard that he went to the Meijer, which was the reunification point on Ray Road. You heard that he saw the police lights, he saw multiple police cars, he followed them. He actually tried to go to the high school first and he couldn't, so he went to the Meijer. And it was there that he learned that there was a shooting at the school, that there was an active shooter at the school. There's evidence and exhibits showing James's movements while at the Meijer. He was there for approximately 6 to 7 minutes. In that time, he texted his son. You can see that on exhibit 375. He called his son to see if his son was okay. He texted his son again. He called his wife. He talked to his wife for about a minute and he left the school. Then he called his son 2 more times. 2 more times in less than a minute to find out if his son was okay. He talked to his wife again for about 10 minutes. You saw a text during that phone call from James's wife to one of her coworkers where she says that their son was the school shooter. Contrary to Detective Lieutenant Willis's testimony that James said his son was the school shooter, he didn't. James didn't say that. You heard the 911 call a few minutes ago. That's not what James said. James called 911 at 1:34 p.m. and said that his son was a student at Oxford High School, and that after he'd learned about the school shooting, that James had gone home. He found the gun and bullets missing. He didn't know if his son took it, that he didn't know if it was him. And if you recall, Nick Ejak and Sean Hopkins both testified that even during the shooting at the school, even after the meeting that morning with James's son and James and his wife, even in those moments, they did not suspect that James's son was the school shooter. Sean Hopkins testified that he didn't even think that it was James's son who was the school shooter until after he checked attendance, after the shooting had ended, and after James's son had been arrested. You heard James say on the 911 call that he was really freaking out. You've heard that a couple of times from James. And you can listen to that call yourself. It's exhibit 154. You can almost hear, as James is talking to the dispatcher, how he's looking back at what had happened that morning and trying to piece things together and figure out what's going on. You heard from James 2 more times within hours of the shooting at Oxford High School, once at the substation and once while in the backseat of a patrol car. At the substation, James learned that his son was the school shooter, that he was not injured or anything, that he was in fact the school shooter. You heard James say he was freaking out. He asked for a water. His mouth was dry. He was freaking out. James was emotional. I believe that Detective Sergeant Bryan testified that James was sobbing, that he was crying. You can watch it. You can see how James was reacting in that interview. Detective Bryan said that James was forthcoming, that he was willing to speak with them, even after James's wife suggested, maybe we should get a lawyer. Maybe we should stop talking. James said, no, let's keep talking. I want to keep talking. It's okay. We can keep talking. And he does. He told the police how many guns were in the home, where they were located, that the handgun that was used by James's son in the shooting was a 9mm Sig Sauer. He mispronounced it. We've all heard that. That it was hidden in an armoire. No one in that interview, neither of those 2 law enforcement officers in that interview said, well, you shouldn't have had it there. Was it locked? How did your son get it? You didn't hear those questions. You heard James tell the police that the handgun was stored unloaded and that the ammunition was stored somewhere else. It was stored separately under some jeans. Again, those 2 officers didn't say, well, you shouldn't have done that. That wasn't right. Well, you did that the wrong way. Well, that was really irresponsible of you, Mr. Crumbleigh. They didn't say any of that. The police didn't ask if the gun was locked or in a safe. James clearly told them that that 9mm was hidden. And the police moved on. James talked about what a great kid his son was, about his mediocre grades, but overall he didn't get in any trouble. You watched as James saw his son for the first time after that school shooting. It was a very brief encounter. And you saw as James was leaving that he repeatedly told his son he loved him. Ladies and gentlemen, you can watch that for yourself. It is Exhibit 301. He repeatedly told his son he loved him. And then after, as he walks back into the first interview room, you can hear him audibly crying, sobbing at what was going on. And what does he say? He asks the police if he can find out where his son is going to be. And they say, yes, the court will tell you. In that interview, you also heard James Crumbleigh say, I wish we had taken him home. In hindsight, looking back, I wish we had taken him home. James had no knowledge that his son had access to any of the firearm, any of the handguns in the home. You saw his son's own words sometime after November 27th of 2021 and before November 30th of 2021. And we know that because in Exhibit 359 on page 22, his son specifically writes 9mm. And we know that there was no 9mm in that home prior to November 26th of 2021. We know that James's son went to the shooting range on November 27th of 2021 with his mom. So we know that that had to have been written sometime between November 27th and November 30th of 2021. We talked quite a bit about this during jury selection. Most, if not all of you, agreed that there's a difference between having access and giving access. We talked about car examples. We talked about the responsibility in different scenarios, a parent's responsibility in different scenarios. This case is like the first car scenario, where the child takes the car without the parents knowing, takes it out when something happens. This is the first scenario. This isn't the second scenario, where the parents might have suspected that their child might do something. This wasn't the third scenario, where James knew his son was going to do something and just handed him whatever it was he was going to do it with and said, here, take it. This is the first scenario, where James Crumbleigh had no idea what his son was capable of. He had no idea what his son was planning, and he had absolutely no idea that his son had access to those firearms. Also, as an aside, if it really were his son's gun, why was it hidden in James's bedroom? If it really were, why was it hidden? Not only in the bedroom, but in a location that James's son was not aware of. Sometime before November 26th of 2021, James's son wrote this in that journal notebook that was found. Exhibit 359, page 15. We know that it was before November 26th of 2021 because of some of the other statements that are around that journal entry, which you can look at if you'd like, but they reference a 9mm and a .22 caliber. And we know that there was not a 9mm in the house before November 26th of 2021. And even here, I don't know where my dad hid it, is a reference to .22 Cal-Tech. Even before November 26th of 2021, well before November 30th of 2021, James Crumbleigh's son didn't know where those firearms were. He told you he didn't, in his own words, in his own handwriting, which was verified by law enforcement. There's no evidence that James Crumbleigh had reason to believe his son would hurt anybody. I went over this a few minutes ago. Christy Gibson Marshall's testimony was that she had known James Crumbleigh and his son since approximately 4th grade. She told a story about James emailing her and asking about getting his son's report card or grades or something along those lines, and she responded and said, give him a hug for me. She testified about everything she saw, heard, and felt on November 30th of 2021. And as I said, she talked about seeing the shooter walking toward her with a gun in their hand. That as the shooter got closer, she recognized that it was James's son. And in those moments, she thought to herself, this can't be right. He's always been such a sweet kid. She was in such disbelief that was his son that she even tried to talk to him. As he's walking through the school with a firearm in his hand, she is trying to talk to him because she just can't believe that James's son was the shooter. And it was when he wouldn't respond that she realized it must be him. ATF agent Brandon testified there were no laws governing the storage of firearms. We went over this a little while ago. We talked about the various ways that you can store firearms. I outlined a few of them. He testified that people store firearms unloaded and unlocked, which in and of itself is not irresponsible or dangerous in 2021. Not putting a gun in a safe or using a trigger lock alone does not mean that that person is irresponsible. Now, ATF agent Brandon gave you his opinion about what he saw on that math homework. That opinion was given within the last couple of days. And with all due respect to Agent Brandon, his opinion on what he saw is irrelevant. It doesn't matter in this case. What matters in this case is what people thought that math homework showed on November 30th of 2021. And those people weren't concerned. They didn't see what Agent Brandon saw. They saw images that weren't concerning, that are common, that other kids write and draw about. The concern was that he was sad and needed to talk to someone. On November 26th of 2021, we saw evidence and heard testimony that James Crumbleigh went and bought the Sig Sauer at the gun store. James had been to that gun store on multiple occasions. We heard that testimony from Ms. Back, who told you that she recognized him because he'd been there before. There were at least 2 other handgun purchases from that store, which we heard about, the 22 Derringer and the 22 Keltec. James indicated, per Ms. Back, that he'd been looking at the Sig Sauer for a few days or a while. She couldn't really remember which one it was. She testified to both. That he knew that that was the one he wanted to purchase. So he did. You also heard Agent Brandon testify about the cable lock that was found in that Sig Sauer gun case. That the sleeve that the cable lock came in was essentially in pristine condition, that the keys were still inside the lock. Now, if you recall, that Sig Sauer was used. James bought that used. That sleeve being in pristine condition means that the person before him didn't use it either. You also heard that James did not purchase ammunition on November 26th of 2021 or at any point prior to November 30th of 2021 for that 9mm. There were purchases for ammunition when he would go to the gun range for the 22s, but James didn't purchase 9mm ammunition before November 30th of 2021. Cammie Back told you that she had, that James didn't even talk to his son while they were standing there in the gun store. She didn't see any of that. She had no reason to believe that James was buying that gun for anyone but himself. And if she had, she couldn't have sold it. So obviously she didn't think that. On November 3rd of 2021, James Crumbleigh and his wife left a hotel that they had been staying in. Well, they had stayed in a couple different hotels, but they left a hotel that they had stayed in after the shooting on November 30th. You heard some testimony, or you heard some information that their residence had been made public, or there was media there, or there were things going on. And you can imagine, I mean, you all can imagine what that was like in the days following the shooting at Oxford High School. You heard Agent Brandon testify today that James and his wife were in and out of that building throughout the day on December 3rd of 2021. You heard testimony yesterday from Detective Willis that they arrived at approximately 11 a.m. and that they were there for the day. They were obviously arrested later that night. But you heard testimony that Luke Kirtley saw at least James Crumbleigh. You heard that James and Jennifer had both gone in and out of the building. Jennifer is his wife, had both gone in and out of the building throughout the day, various times to smoke walk out to the car. Sometimes one of them went, sometimes both of them went. December 3rd, 2021 was a Friday. It was a work day. They were in and out. You heard that there were at least 14 cigarette butts found near their vehicle. You saw over 300 exhibits during this trial. You heard testimony from over a dozen witnesses. None of them told you that James knew what his son was planning. None of them told you that James knew that his son was a danger to anyone. None of them told you that James knew that his son knew where those firearms were hidden. None of them told you that James knew that his son had somehow obtained access to the firearms that he had been hiding. None of them told you that. Because on November 30th of 2021, James Crumbley had no knowledge about any of that. He had no knowledge and he had no reason to suspect what his son was planning to do later that morning on November 30th of 2021. Now, every time I do a trial, I have somebody tell me that they think of a reasonable doubt that I may not have thought of. So think of your own. You don't have to agree with all of mine. You don't have to agree with any of mine. You can come up with your own reasonable doubt based on the evidence that you've seen, the testimony that you've heard, your collective memories. You can come up with your own. You're not limited to what I've come up with, and you can certainly reach your own reasonable doubt conclusions on your own. And as you deliberate, think about the things you did not hear during this trial. Think about the things that you were told you would hear during the opening statements, that you would hear how the shooter gained access to that gun. You didn't hear that. That you will hear from school officials regarding their concerns about the math worksheet. You heard that they were concerned about sadness, not about danger to others. That you will hear that the need for immediate parental intervention was necessary. You didn't hear that. In fact, you heard the opposite. You heard that Sean Hopkins said that James and his wife, that they wanted James and his wife to have their son talk to someone or to at least make arrangements within 48 hours. No one testified that immediate parental intervention was necessary on November 30th of 2021 during the meeting with Sean Hopkins and Nick Ejak. No one testified that there was a need for immediate intervention of any kind, discipline, mental health, or otherwise. You did not hear testimony detailing how the shooter obtained access to the 6 Sauer. You just saw in his journal that he said he had access, but you don't know how that happened. No one testified that the shooter knew that there was any sort of code to open the gun safe. There's been some talk about the code that was used on the gun safe with the Keltec and the 6 Sauer. There was no testimony that the shooter even knew about that code or what it was. You did not hear any mutual concern for the shooter's well-being from his best friend's dad, who you saw text with between James and his friend's dad, who obviously has experience with mental health with his own child, from what you can see in the texts. And even that man didn't express any concern for James's son. In fact, on November 30th of 2021, he texted James, said, "I hope everyone's okay." No one told you that James Crumbley was aware of the texts or videos that were sent to his son's friend. In fact, they all testified, all of the witnesses testified they couldn't tell you that. They couldn't tell you that he was aware. You don't know if the shooter ever actually did do what he told his friend he was going to do. He was going to tell his parents about this, that, and the other. You heard no evidence that he actually did. You heard no evidence that he actually told James any of that. And when you go back for deliberations, think about everything that James Crumbley did not know. He did not know he had to protect others from his son. He did not know he wasn't exercising ordinary care in the way he was storing his firearm because he didn't know that his son was planning what he was planning. He did not know that it was reasonably foreseeable that his son would commit these offenses. He had taught his son safety. He had taught his son to be familiar with those firearms because they were in the house. He had no idea what his son was planning to do. In fact, no one that interacted with James Crumbley's son on November 30th of 2021 knew what was going to happen a short time later. No one. And this is the part of the trial that I dislike the most. The prosecution gets to stand up and make a rebuttal statement, and I have to sit down and I don't get an opportunity to respond. That's how trial rules work. The court has told you that. That's just how it works. But the hard part for me is that every time I hear a rebuttal from the prosecution, I think of all these things that I want to say. Think of all these responses that I can give. So what I'm going to ask you to do, we've gotten to know each other over the last couple of weeks. You've seen how I am in court. You've heard the questions that I ask. So when you go back to deliberate, think to yourselves, what would Marielle say? What would she say about this? What would she say about that? Because unfortunately, I can't tell you. I join with the prosecution in thanking you all for the time and attention that you've paid to this case. You have heard some of the most emotional testimony and seen some of the most difficult things that I can imagine a juror could see. And you likely may not be able to forget it. But what you're all doing in these chairs is of the utmost importance. And I thank you for the time and attention that you've paid. Early on in this case, during our opening statements, the prosecution and I both asked you to follow the law. And I'm going to ask you again, follow the law. The judge will instruct you on what the law is. She will give you very clear instructions. Please follow the law. Review the evidence. Review the instructions and follow the law. Because I'm confident that if you do that, each of you will have at least one reasonable doubt, and your vote will be not guilty. And your vote should be not guilty, not just because you have reasonable doubts, but because James Crumbley is not guilty. Thank you.
Thank you, Ms. Lehman. Rebuttal, prosecutor.
That was definitely much, much stronger than Jennifer Crumbley's closing, Shannon's closing for Jennifer Crumbley. Much stronger.
You know what my least favorite part of the trial is? It isn't listening to the defense argue that her client is not guilty. She has a right to do that. It isn't even listening to what I believe, and I'm going to tell you what I think is inaccurate. My least favorite part of the trial is that even where we're standing here and our criminal justice system provides for justice for victims, and my job is to advocate for them, and I'm standing up here and I'm doing that. I've been doing that all week and several weeks before, and I'll keep doing it. You know what my least favorite part is? It doesn't take away any of the suffering. It doesn't take it away. So don't deliver a verdict thinking that it will, because it doesn't. Your job is to follow the law and use your common sense when you consider the evidence. I embrace the high burden of beyond a reasonable doubt. I believe in it wholeheartedly, devoted my whole life to it. I embrace it. It's what we use for every prosecution in this country, every single day of every year, for decades and decades and decades. That's the burden we have. And it is not, despite what the argument is always, any possible doubt. you have to be 100% sure. If you're 100% sure, we probably don't need criminal trials. And you can't be. We can't be. That doesn't make any sense, does it? We can't get inside the head of people who commit violent crimes or any crime and decide what they knew and what they wanted and if they loved their kid. I hope he did. I hope he does, by the way. I assume he does. We all do. We all love our kids. That's not my job. It's not my burden. So I embrace my burden, but I'm not going to embrace something that's just not true. Because it is not true that I have to prove, and the people of the state of Michigan have to prove, what James Crumbley knew. It is not true that the people of the state of Michigan have to prove that he knew his son was going to kill somebody. We've talked about this before. If that were the case, he'd be charged with murder. That's not my burden. That is not what I have to prove. The judge is going to instruct you what burden. It's a reasonable burden, and it's as to the elements that I have to prove. Only the elements. Beyond a reasonable doubt, using your common sense and your reason. The elements, and what are the elements? You're not going to hear that the elements of this crime are that I have to prove what he knew, what he actually knew. That's not the law, ladies and gentlemen. That is not the law. The law is I have to prove beyond a reasonable doubt what a reasonable person would do using ordinary care. That's what I have to prove. There's a couple things I have to correct. The questions defense counsel asks witnesses are not evidence. It's the answers that are evidence, and you have to decide whether that's credible. But Special Agent Brandon did not testify that it was safe. He would call that secure if an unloaded gun was stored separately. In fact, that's not what he testified. What he testified to was that it wasn't storing the firearm or ammunition wouldn't make it secure if you had a 15-year-old who knew how to load and shoot that gun. That was his testimony. You did not hear from people at the school that they were not concerned. That was not the testimony. You did not hear that James Crumbley went home because he was trying to check on his son and he was worried. None of that happened. You heard the 911 call. You have to rely on what you heard, not the questions that were asked. Defense counsel put up a statement from the Journal about my gun and where my dad hid it. And she's urging you to find that credible. But if you do, and we argue you should find, it's all credible. You don't get to pick one statement from a journal and say he was telling the truth there. But all the stuff about how he asked his dad for help, that wasn't the truth. You have to use common sense. And I'm not going to go through every single thing that Ms. Lehman told you, because I know that you were all taking notes and you all listened to it. And I laid out, and I know you remember the testimony. But the one thing I'm just going to ask you one more time is, I embrace my burden, but you have to hold me to the law and what I actually have to prove and what the judge tells you I have to prove, which comes down to common sense and reasonableness. Let's step back. We have a person, we have a father who purchased a gun as a gift. He knows he has it. He knows how to use it. He knows he's in the house by himself after it's purchased. He gets called to the school. And the words on the paper, the drawing on the paper is of that gun. You heard Special Agent Brandon. The testimony speaks for itself, and so does the drawing. He saw the words, blood everywhere. He saw the image on the paper with the bullets and the person bleeding. He understands exactly, because the image is there and you saw it, that's exactly where those bullets landed. The thoughts won't stop. Help me. I want help, but my parents don't listen to me, so I can't get any help. And then that day, just hours before, help me. Use common sense. It doesn't make any sense to stand here and say someone had no idea that he needed help when he saw on the page, help me. It doesn't make any sense, because any reasonable person, which is the standard you have to use, using ordinary care, would know that, because it actually says, help me. The world is dead. My life is useless. Those messages you saw, that's exactly what he thought. We know what was going on because of the messages in this journal. And then we know there was a cable lock. You did not hear any testimony about who owned that gun and whether that lock was used or another lock was used. But you do know that whoever purchased that gun had to be 21 years old. You do know that. We've been telling you since this case started, it would take tragically small things to make this, to prevent these deaths. And you are hearing a lot about how to store a weapon. And the truth is, this has nothing to do with a safe storage lock, and you don't have to lock a weapon up to make it secure. There's lots of ways to make it secure. But what isn't secure is leaving it around, which we know he did with his other weapon, leaving it around. My dad left it out, LOL. I thought, why not? Loaded, knowing that your ammo is right there. We know that is not secure. But let's talk about one of the ways that we can prevent access to minors. This is the murder weapon. This is the gun. We know, we presented evidence of this. I'm going to put it right on the table. This is a cable lock. This little piece of cord. This is me inserting the cable lock. We know that a cable lock was in the home. We know it was provided. This is me inserting a cable lock. That takes less than 10 seconds. Takes less than 10 seconds. 10 seconds. You don't have to go find it. You don't have to go buy it. It was provided. It was right there. You just watched me do it. 10 seconds of the easiest, simplest thing. One of which, by the way, not the only way. Locking was not the only way to prevent this, but it was one way, and it took less than 10 seconds. Let's talk about the gun being hidden. Let's talk about that. You heard the defendant's sister say, yeah, he went and got the gun from his bedroom. These are the other two guns. Ladies and gentlemen, the guns were kept in the bedroom. The family was there when she was told that, and everyone knew the guns were kept in the bedroom. This is where he says he hid the gun, the armoire. This is what it looked like that day. Wet towels folded over it. It wasn't even closed. He says it was in the armoire under some jeans. This is not hiding a weapon. This is just where you kept it. It is not reasonable to conclude that a 15-year-old who spends all kinds of time in the house alone would not know where it was, because it wasn't hidden. This isn't a case where we have a parent who hides a weapon far out of reach from a child who couldn't get to it, doesn't know it exists, ammunition in a totally separate spot. The kid, that's not this case. It's reason and common sense is what we have to use. We know that James Crumbleigh went home and looked for a gun when he heard there was an active shooter. And we know he referenced there was that meeting at the school. That's foreseeability, and that's a person who suspects their own son. And that is what I have to prove. Foreseeability to an ordinary, a reasonable person using ordinary care. This case is not a statement about guns. It's not a statement about parental responsibility. It's not about kids doing kids things. The kids on November 30th in that building were doing kids things. Hannah, Madison, Tate, Justin, they were going to class. They were talking to their friends. They were dancing in the hallway. Those are kid things. Parenting is the hardest job that we'll ever do. The hardest job, and one of the most important ones, but it's exhilarating and joyful and the best experience of our lives. We look at our kids when they're born and we see hope. But they can break your heart. They're supposed to. They have to leave someday. They don't come with a set of instructions. I'm not here to tell you that this case is about somebody who didn't follow the instructions to be a perfect parent. But we do have a guide. We do have a basic standard for ordinary care. We all have doubts about our kids. We all worry every minute of every day that they're going to do something or something's going to happen to them, and then it might be because of something we did or we didn't do. We are not responsible for everything our kids do. This prosecution in this case is not inconsistent with that. It just isn't. This is a very egregious and rare set of facts. We do have a measuring stick, ladies and gentlemen, and it's the law. And it requires us to use ordinary care. And there is a consequence if we don't, in a very limited way that the law allows a parent to be charged. Your job now is to go back there and use your reason and common sense and follow the law. That's what your job is. You've listened to all the evidence, and at the end, you will conclude that James Crumbleigh failed. He might love his kid, I hope he does. But stick to what I have to prove. Stick to what I have to prove. And remember that he didn't just fail in his duty to his son. He failed in his duty to protect Hannah and Justin and Madison and Tate. And I don't say their names to evoke sympathy. I say their names because they matter. They matter. And that is why we are here. We are absolutely here about what happened in that school that day, because if James Crumbleigh had done even the smallest of things, like the 10-second cable lock, or gone home, or took responsibility for his kid who was in trouble, those kids wouldn't have been shot and killed in that school on that day. I have met my burden. Mr. Keystone, the people of the state of Michigan have met the burden to find James Crumbleigh guilty of 4 counts of involuntary manslaughter. And I ask you to return that verdict. Thank you.
Thank you, prosecutor. I'm now going to read jury instructions to you. Does anybody need a break before I do that? Oh, we need a break. All right. You're going to get a copy of these jury instructions in the jury room, all right? Members of the jury, evidence and arguments in this case are finished. I'll now instruct you on the law. That is, I'll explain the law that applies to the.
All right, y'all. Wow. Wow, 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 wow. So here's my take on what we just heard. The state, their closing was, it was reasonably strong. I felt that the state's closing was stronger in the Jennifer Crumbley trial. In terms of its presentation, in terms of, just the smoothness of it, in terms of the passion, Karen McDonald is her name, the prosecutor who gave the closing. She's really good. And you can tell though that today she wasn't totally on her A game. When during Jennifer Crumbley's closing, she was on her A game. She really brought it. I thought that the defense's closing by Muriel Lehman was probably as strong as it can be. I thought she was really, really good in terms of her ability to, go through all the evidence, go through all of the, all of the possible ways that you could think about it differently for James, right? She didn't make it about herself. She is a stark contrast to her former partner, Shannon Smith, with the one major exception of they used the exact same line at the end of their defense, which was, "This is my least favorite part." Yeah, she was definitely loud. You could definitely hear her. She doesn't have that problem. But her least favorite part of the trial is the fact that now she has to sit down and the state gets to get up and give a rebuttal, and she'd like to be able to give rebuttals to the rebuttal, but she can't. And so she would like the jury to go back and think, what would Muriel think to all of these rebuttal statements that the state is making? So obviously that's something I would bet you anything if we went through YouTube and tried to find Muriel or Shannon giving closing arguments in other trials, you would probably hear the same thing. Now, here's where I have a problem with the defense's closing, okay? Her whole premise, the entire premise of her closing was, how could he know? How could he know? How could he have known that his son, how could he have known that his son was going to conduct a school shooting? And her argument was also that the prosecution has not met their burden in proving that her client could have known or did know that his son was going to go off and do a school shooting. That is not what the state is there charging. The state is not charging that James Crumbley knew that his son was going to conduct a school shooting, because if the state thought that James Crumbley knew, they would be charging him with actual murder. They would not be charging him with involuntary manslaughter. So, and I'm thinking that the jury is probably going to be, yeah, no, I know that's her job, Johnny. I agree. That is her job to do that. It's frustrating though. It's frustrating, for to hear kind of disingenuous arguments like that, because what, anybody who wants to excuse the actions of James Crumbley is going to take those arguments and run with it. Anyone who wants to look at this situation and say, hey, I would do all the same things James Crumbley did in this situation, and say that that's okay. I'm sorry, but I cannot look at all of the facts we know about this situation. Me personally, if I were on that jury and I heard all of the things that were done and not done in its totality, I would be voting guilty. And here's why. Because I know for a fact that if I saw this, okay, if I saw this on my kids' homework, I would be freaking the fuck out. If I saw this on my kids' homework and I knew that I had just bought that specific firearm for my kid, and I also knew that he had just gone through some personal trauma, I would be freaking the fuck out. I wouldn't be leaving him at school. And let's just say I did leave him at school. Let's just say I did leave him at school. I would be racing home. I wouldn't be picking up my DoorDashes. I wouldn't be picking up work. I would be racing to my house to see if that gun is where it's supposed to be, where I last left it. Okay? And I may not have thought that he was going to, shoot a bunch of other people. I might have been worried. I might have been worried that he was going to hurt himself. And that's enough of a reason to race home, either take him out of school and start counseling immediately, right then and there, or leave him at school and race home and see if he has possession, see if that gun is where it's supposed to be. If I go home and I see that the gun is not where it's supposed to be, I'm immediately going back to the school. That's true. I don't have a horse. But I'm immediately going back to the school and seeing if he has that gun with him. None of those things were done. None of it. None of it. There were DoorDashes. There were visits to the horse farm. There were, calls to other people. There was to me, reasonable care was not taken. And if there is a not guilty finding in this type of a situation, then you're sending the message to parents everywhere that it's okay to raise children with that amount of absolute dissociation from what's going on in your kid's life. You should, he did know that his kid was going through a hard time. He actually did know. But he was minimizing it because he didn't want to raise red flags for the school, right? But it wasn't sinking into him enough to want to be bothered to actually press upon his wife that they need to go seek help for their son immediately. And don't forget that he is the person who brought his child to the gun store with him to buy that gun and implied that is your early Christmas present. And in talking about, so let's just explore this idea of, having a gun in the house with a kid. Okay. There is nothing wrong. There is nothing wrong with having firearms in a house with kids. Nothing wrong with that whatsoever. There's nothing wrong with taking your kids to the shooting range and teaching them proper firearm safety and handling. However, if you're going to do that, you also have to understand that kids are not old enough to handle them responsibly in their own on their own. So you have to secure them. You have to put them in a place where they can't access them or operate them if they can find them. So it is your responsibility as a parent to put it in a place that either can't be found or lock it in such a way to where it can't be used. And none of that had been done. Let's just look at the facts here. We know that the cable lock was found completely unused, and that the key to the cable lock was still inside the lock, never taken out, never used for securing that firearm. And that the gun safe that they did have was still on the default setting. They probably didn't even have to put in the 000 in order to open the gun safe. It was just kind of there for show, in my opinion. This is just my opinion at this point. But if you're going to have a gun safe, why on the fucking earth would you keep the combination at 000 when it probably came like that? And when you have a 15-year-old kid who is interested in firearms, who's home a lot on his own, and you as a parent know that you're not telling everybody everything about what's been going on in the home, that your kid has been talking about the voices or the things flying around and flying around the house, and that he's been texting your wife for her to come home because he sees things flying around and everything's just been laughed off and laughed off. You know that as a parent. You know that more stuff has been going on, that just the night before the incident where he murdered those 4 children, he had been locked out by his parents because they had gotten in that fight about grades. There are multiple triggering incidents. So if you're a parent and you know that you and your child had just gotten into an argument the night before, you get called into school the next day, you see this homework, and you still slough it off, that is not reasonable care. And I'm sorry if that's hard for some people to hear, but it just isn't. It just isn't. Johnny says, if I had guns and kids, I think I'd be terrified that the kids might get to them. I once found parents' well-hidden VHS with porn, and it was traumatizing. I know, exactly. Oh, dude. I was the nosiest child on earth. I was home alone so much as a kid. I crawled all over my my mom's stuff. I found everything I could find, and I didn't find much. I found, the most scandalous thing I found were letters that my father had written to my mother from jail, and I didn't know, and they were long divorced by the time I found these, but I didn't know that he had been in jail. That was how I found out that he was in jail at one point. and it was before I was even born. So that was the most scandalous thing I found. But yeah, I was left home alone, and if I was a very troubled kid. If I would have found a firearm, I don't know what I would have done with it. I really don't. But, we're going far afield now. Point being, it is your responsibility as a parent to know what's going on in your kid. Yeah. It was a little bit more, I don't know. It might have been more traumatizing to find porn, Johnny, but, because I was kind of young when I found it, and I don't even remember what was said in the letters. And when my mom realized I found the letters, she burned them basically. Here's a funny story. I don't know why, but my dad sent my mom a Hershey bar from prison. A Hershey bar. I don't know why he was sending her a Hershey bar. Maybe it was an inside joke or something, special to them. But, and again, I found these letters years and years after, all this stuff happened. And I tried to eat the Hershey bar. And that's probably what I was looking for in the first place. I was a food hound. I was crawling around the house looking for sugar and sweets, and I was like, "Oh, damn, here's a Hershey bar." And I tried to eat the Hershey bar, and I chomped into it, and it was disgusting. It's 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 a wonder I didn't get like poisoned from it or something. But anyway, my prediction is guilty on this. That's my prediction. And I don't say that with pleasure. I don't say that with glee. I don't wish horrible, horrible things on this father. I just do think that he failed to show a duty of care. I really do. I do sincerely believe that. So, and honestly, I do feel that if his wife was found guilty, he should be found guilty too, because they showed about the same amount of irresponsibility, each of them. So we are now basically on verdict watch. The jury is still getting their instructions from the judge. I will I will go live when we know that we have a verdict. Let's see. So it is 3:00 their time. They will probably go on, some sort of 10, 15-minute break. So by the time they really start deliberating, it'll be at least like 3:45 their time. If they come back with a verdict today, that means it'll be a very, very, very fast verdict. Very fast. That would be like within 1.5 to 2 hours. My guess is that they probably won't come back until tomorrow, because the jury was, their expectations were set to go for the rest of this week. And so they're probably okay with going one more day, like tomorrow morning, and then going to work in the afternoon or something like that. I can't speak for all of them, but just as a reminder of the makeup of the jury, there are 9 women and 6 men. And there's a music teacher, a stay-at-home mom, a graphic designer, a machinist, a retired widow, a nurse, a retired nurse, an unemployed person, a Stellantis IT worker, and an engineer. So there's like a good mix of, professionals and blue collar workers, and, looks like age range. You can't speak for the age range of the people who are not retired, but, I think there's a pretty young population there. Anyway, so it'll be interesting. It'll be interesting to see. Yeah, and they took a little bit of time to argue about that with Jennifer Crumbly, Johnny, so they might. So anyway, I want to thank you all for being here, for being responsible in the chat, and respectful. And as I mentioned before, I do plan to go live on my other channel, Checkmate Humanity, for a reality check on Bullhorn Betty soon, maybe tonight. So be on the lookout for that. And otherwise, have a wonderful, wonderful rest of your day. Don't forget to hit the like button. And I will talk to you very, very soon. Bye-bye.